Development has in both of us. This is another appeal. Can it be taken up next week or day then after 2 weeks?
Next week.
Or maybe after 2 weeks. That will be
Item number?
better. After 2 weeks,
Then
captain's part had.
part heard.
This part heard?
ये part heard my lord.
No, captain's part had after 2 weeks.
No, it was heard or not?
It was heard, substantially heard, my lord. There is an order also, if your lordship peruse, my lord. It is substantially heard. The question was on from which did the insurance policy would commence, my lord.
But there
Can-
is, okay,
Can it be on
we,
11th, 11th of November?
no fixed date. Heard. Mr. A. Lal, learned counsel for the petitioner. Appellant. Also heard Mr. R. Goswami, learned counsel for the respondent.
Yes, sir. I'm appealing in one case.
I am appealing in one case.
In 12, in item number 12, this will be the order. Item number 13, reverse করে দেব. It is submitted at bar. An adjournment prayer. Who is making the prayer?
My lord.
Mr. R. Goswami has made a prayer for adjournment on the ground of personal difficulties, to which Mr. A. Lal, learned counsel for the other side, does not raise any objection. The prayer is allowed. Hence, the prayer is allowed. Let this matter be listed in the second week of November on a date to be fixed by registry.
As part heard, my lord.
No. If it is already part heard, it will,
If your lordship kindly peruse the order, my lord, it is already part heard, my lord.
then it will remain as part heard.
But your lordship has not specified it. That is a difficult.
Then I will not specify it now.
Because it does not go to other bench also if your lordship is not taking up the matter, my lord. And second,
No, only reason that I have not made it part heard earlier.
lordship has
Therefore,
stated
while
that-
mentioning it may not be proper.
No, my lord, on the order, in the last order, it was mentioned, my lord, that the matter was substantially heard.
That is enough. That is enough.
That is enough, my lord. That's why I'm praying, my lord. If it is specified, my lord, it will come on that day, my lord.
No specifics.
I am obliged, my lord.
May I please, your lordship? I am the appellant of item number 11.
Yes.
Due consent of the other side. This matter may kindly be adjourned due to the surgery of hip ball joint of learned counsel Mrs. K. Yadav,
Okay. What is your name?
Meenakshi Bhattacharya.
Heard Miss M. Bhattacharjee, learned counsel for the appellant. Who is for the other side? Also heard Mr. R. Sharma, learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground that Miss K. Yadav, learned counsel for the appellant, is indisposed. The prayer is not opposed to by learned counsel for the respondent, hence same is allowed. Yes, next.
Fixed after 5th December.
Registry will fix it. I am not mentioning anything. Yes, Mr. Sharma.
Item number 2, Lord. In this case, Lordship, I have an addition affidavit, but till now it has been not annexed with a record, Lordship. I will verify, Lordship. Can it be on 5th of November, Lordship?
Who is for the other side?
I am for the petition.
Heard Mr. R. Sharma, learned counsel for the,
Lordship,
sorry. Heard Mr. A. Sharma, learned counsel for the respondent, who submits that he has filed an additional affidavit in this case, which is not yet tagged with the case record, and hence prays for an adjournment. The prayer is not opposed to by learned counsel for the petitioner, Mr. R. Sharma. Hence, same is allowed. Let this matter be listed after 2 weeks, after
5th of November. Otherwise, it will be listed, Lordship, because affidavit has been filed. Lordship, hard
in the next week on a date to be fixed by registry, along with the additional affidavit filed by the respondents.
obliged.
May I please, your lordship? I beg to mention item number 14, your lordship, and list the matter after I wish, lordship.
Item number 40,
40.
14.
I have no any objection.
Heard Mr. What is your name? T. Sheikh, learned counsel for the appellant, also Miss J. Chetri, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulties. The prayer is not opposed to by learned counsel for the appellant, hence same is allowed.
May I present? So I beg to mention item number 4, madam. In this case, TCR was called for, that is not received now. I have been informed by the local council, my lord. TCR already sent from there. So my lord, kindly a short date may be given on Friday.
Have you verified from records?
I have been informed by the local council, she verified there.
Know whether it has been received or not. Item number 4, we,
See, my lord. Because it is not shown in the court list. Yes, my lord.
okay. Heard Mr. A.K. Azad, learned counsel for the petitioner, also heard Mr. K. Bushra, learned additional public prosecutor. The scanned copy of the trial court records have not yet been received. Hence, issue reminder for the same. Registry to take steps for issuing reminder. Let this matter be listed. When?
I'm praying for Friday, my lord. That is my, I already sent from there. I have, as per my information.
On 31st of October.
Must.
Right, please, your lordship. Your lordship, I beg to mention item number 18, lordship.
Yes.
Yes, I prefer assuming for lordship today. Carnatic Council, Mr. NNM has gone to Bombay due to certain unavoidable circumstances. We have taken the consent from the other side, lordship.
You are for?
And for respondent 1.
Heard Mr. S. A. Bakhtiar, learned counsel for the respondent number 1, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed the counsel for the appellant regarding his prayer for an adjournment, who has no objection to the same, hence the prayer is allowed.
Lordship, a date, please.
No date.
After 24/11.
What is your name? Also heard Miss M. Burman, learned counsel for the appellant, who has no objection. Let this after 24/11. Let this matter be listed in the first week of December on a date to be fixed by registry.
May I please, your lordship? Lordship, I beg to mention item number 21. Lordship, matter may be approved for today.
21, what is your prayer?
Lordship, adjourn today.
Why?
My senior is suffering from health issue.
You are for
B. Setia.
B?
Setia.
23.
21. I'm for petition under this.
Okay. Heard Miss, what is your name?
B. Setia.
Heard Miss B. Setia, learned counsel for the appellant, who prays for an, you have informed the other side.
Lordship.
No, you inform. First you inform, then you have to make mention. Otherwise,
Lordship.
we will also allow your adjournment when the matter is called. Not at this stage. Without informing the other side, please do not mention. We will allow your prayer when the matter is called up. You first inform, then make mention. You mention at 2. I will allow you, but you first follow the norms. Please mention again at 2 p.m.
Oblige, your lordship.
Item number 1. Madam, this is the benefit between regular basis. My learned senior counsel BP Todi lead the lawsuit in this case. And LCR has already been called for review and most probably it has been received. Notice has already been served on the victim lordship.
Victim is represented.
I am not sure, lordship, but notice has been served for our information. And our main ground is,
Trial court record.
our main ground is on
Victim.
the 748 lordship.
Mr. Agarwal, you are representing?
But my name is come while deciding the matter under 48 notice.
No, notice has, victim has to be represented by someone.
For the case is concerned, my lord. My lord, if your lordship permits me, my lord, to say only 2 words, my lord. My lord, our main ground is on the constitutional.
48, 47.
Yes, my 47, 48, my lord, the constitutional matter, my lord.
But still victim has to be represented.
Notice is
We,
filed,
we,
my lord.
we will appoint one amicus curiae and fix day after tomorrow, short date.
Subject conveyance, lordship conveyance. Can be taken up tomorrow, my lord.
Any amicus present in the court.
Last occasion, Lordship, earlier bail petition, Lordship has appointed Advocate Sarfraz Nawaz.
We'll appoint him again.
Lordship, if
Yes,
you
Mr.
can inform.
Heard Mr. BP Todi, learned senior counsel assisted by Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. K. Busher, learned additional public prosecutor. On perusal of the office note, it appears that the scanned copy of the trial court records have been received. It also appears that notice issued to respondent number 2 has been, 3 has been duly served, but no one has appeared to represent the victim girl. Hence, this court is inclined to appoint one amicus curiae to defend the cause of the victim girl in this bail application. Accordingly, Mr. Sarfraz Nawaz, learned counsel whose name appears in the list of amicus curiae prepared by registry is hereby appointed as amicus curiae in this case. The petitioner is directed to serve, furnish a copy of bail application along with annexures to newly appointed amicus curiae. The registry is directed to reflect the name of newly appointed amicus curiae in the cause list henceforth. When?
Can you, my lord,
Is the IO head mentioned by name in the, while deciding the matter in the court below lordship under section notice of 47 and 48 lordship. And the report was called by the court below lordship that whether 47 and 48 has been complied with, because the whole matter depends upon that section only at this stage. So the court below has rejected the bail petition, stating the ground that report of the IO that 47 has been complied with and 48 has been complied with through me, lordship. So I want to give affidavit only. Because there is report from the IO in the record, lordship.
Yes, Mr. Bushaw.
May I say something? My lord, may I say something, my lord?
Yes.
My lord, so far the prayer made by the individual counsel, my lord, but he is not in this case. Number one, but he if some place he is aggrieved by anything, my lord, he can file separate petition altogether, my lord, to expunge his name from the proceeding, whatever it may be, my lord. But whether, my lord, in this case, he is permissible to, my lord, interfere, where he is not in the case.
my lord, what I understand is that, my lord, here is a case, my lord, in this case, my lord, there are 3 numbers of respondent. One is state of Assam, my lord, who is represented by the state prosecution. Apart from that, my lord, there is the respondent number 2, the informant who is a police personnel, my lord. WSI, my lord, Pranita Gogoi, and respondent number 3, who is a victim, my lord. Victim of the case, my lord, where in this connection, my lord, that is already police had served the, my lord, notice, my lord. That part is complete. What I understand is that for the respondent number 2, as because he is a police personnel, my lord, and the, my lord, arrayed as a respondent number 2, my lord, in this case. So he was, my lord.
No. That is not his case. His case is that his name has been involved. During investigation, a plea was taken that 48 notice has been served on somebody on his instructions. That,
I'd like to clear, lordship.
no,
Thing is,
keep it for next date. You remain present. We are not showing your presence.
my lord.
If necessary,
because the thing is.
not now, on the next date fix. We are not reflecting your name as party. If required, we,
Council was also representing the accused in the first bail petition, in the trial court bail petition before
okay,
trial.
okay, no, let him remain present.
Lordship,
When,
it's on that day also.
when should we fix the case?
Or subject lordship convenience, my lord, sooner the better, my lord.
Maybe
No,
tomorrow or day after tomorrow.
at
Tomorrow is
least
possible,
some
Lordship.
notice,
Notice I can serve today itself. By within half an hour, I can serve to, or maybe by 1, I can serve it to Advocate Navaraj with all copies, Xerox copies.
tomorrow.
I can personally inform him. Lordship.
Let this matter be listed again on 29th of October.
Obliged, Lordship.
Item 5.
Sir, item number 5, my lord, CD not received, my lord. So pray for a my lord, short date, my lord.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor, who prays for some time for production of the case diary. Some more time for production of the case diary. Prayer is allowed. Let this matter be listed on
Third, my lord, 3rd of
3rd of November.
Much obliged. Much obliged. Item 3.
In this matter, senior counsel, Mr. TJM on the speeding, your lordship. He's placed in a division bench, your lordship. And the matter may pass off for timing, your lordship.
For the timing. We'll take it up after some time.
20 supplementary.
May I please, Lordship? I am appearing for the sole respondent. Matter is fixed for admission, actually. There is no merit at all in this matter, Your Honor. Trial court record is also halting since last 1 year. No progress has been done in the trial court proceeding.
Who is for the,
Short date may be given, Lordship.
none has appeared
Yes,
for the,
giving a last opportunity to the other side.
none has appeared. No, it can be dismissed even today.
Yes.
It
yes,
is fixed
given-
for admission hearing.
Yes.
None has appeared for the petitioner on call. Mr. H. K. Sharma, learned counsel for the respondent is present. Let this matter be listed again on day after tomorrow.
Day
That is
after tomorrow. That means on 30th.
30.
30th, I have number of cases.
You
30th.
suggested it.
Maybe on next week, Lordship.
On 4th of November.
Must have.
For hearing under order 41 item 6.
24.
Item number 24.
But he has told me.
It is the yesterday's matter.
Yes, my lord.
Mr. Datta is
Yes,
appearing.
yes, my. He has in fact, the junior has informed me that it will be taken up at the first half of it, 10th.
Let him come. We'll take it up after some time.
Will inform.
6. Item number 3.
None has appeared for the appellant on call. Let this matter be listed in the next week on a date to be fixed by registry.
Item 7. Item number 7.
None has appeared for the appellant on call. Let this matter be listed in the next week on a date to be fixed by registry.
5 from supplementary.
Item 25 and 26 have identical questions, Lordship. in
20.
this case have arisen out of this. Our rejection of our appeal by the first appellate court, that is the Civil Justice Senior Division, which was filed challenging an order passed under Order 21, Rule 97, 99, 101, 102 by the Munsif Morigaon. Lordship, the fact is, in both the cases practically, we are the obstructors of a decree. In the first, Ananta Boiragi,
You were not party to the suit.
not party to the suit. We have never been made party to the suit, knowing fully well that we are in possession of the suit land. In RSC 175, we have purchased the land by a Kacha deed in 2004. Suit was issued in 2008, knowing fully well that we are occupying a part of the land, 4 bighas of land. 4 kathas of land. Then the matter went up to High Court. Decree has been given in favor of the plaintiff. And when they went for execution, then only we came to know that we have been made, the decree has been passed on our land.
High Court in second appeal.
This is second. No, High Court is second appeal affirmed the decree.
Okay.
And when the execution started and the court Nazir and Mandal with police went there, then only we came to know, Lordship, that there is a decree over our plot of land which we possess. We have never been made party by the plaintiff, not been informed by the respondent that yes, they are.
Then
not-
you file this order 21 rule 97 petition
No,
before the,
during execution,
before the executing
the
court,
execution.
executing court. What happened there?
they rejected the petition in limine. That is the impugned order, Lordship. Twenty-eight, Lordship. It is further submitted the original owner of the possession of the said land was one Bodhan Medi who was financially crisis sold the land in 2004. This is a suit of 2008. Simply without anything, the petition has therefore prayed for following relief, right, title and interest, issuance of precepts. Then it is settled question of law that what a party comes under order 21 rule 19 must claim right, title and interest. This is also a wrong assumption, Lordship, here. In the instant petition has also claimed right, title, interest, but the claim is not supported by any cogent and reliable proof of documents. This is the finding. The petitioner has relied upon an unregistered sale deed. It is the pertinent to mention here that sale deed is an essential formality of a transfer of immovable property. Those are the questions, Lordship, have to be decided in the petition, which shall have to be treated as a suit, not in limine. No notice have been issued, simply respondent was present on that day. Then again, we preferred an appeal that was also in the similar manner. Decided, Lordship?
Where is the appellate's court order?
Yes, Lordship, at page 31 to 44, Lordship. Some observations have been made against us, Lordship, here. Thus, I am of the consider that the present appellant is also part of the bigger game of frustrate without anything, Lordship. We have not been properly heard. Once a suit has to be 2197, 99 proceedings have to be decided like a suit. At least.
So you were
court can
not
file
allowed to,
preliminary issue,
you
no
were
problem.
not, no issues were framed.
Not even, no WS have been called for, Lordship.
You
in
were
this.
not allowed to adduce any evidence.
Maybe there, Lordship, a circumstance may appear, Lordship, where a court can decide the matter in a preliminary issue. But there must be, our petition should be treated as a plaint. They have to submit their written objection, whatever they may, then court may frame. If some legal questions arise, they may frame a issue, preliminary issue, when
Which,
maintainability of our petition.
what is the substantial question of law?
We have framed here, Lordship, at page. Page 12, Lordship. Para 15 of our appeal memo, Lordship. Whether a petition filed under 2197, 99, 101, being a suit by itself before the executing court, filed by the third party can be disposed without following the procedure of the suit. And then whether a court exercising the original jurisdiction in a civil suit can proceed to pass its judgment and order, firstly without framing issues, necessary to adjudicate, and secondly, without allowing to adduce evidence by the party filing the suit, particularly when plea of acquiring right title and interest are taken. Secondly, we have this ground C have been taken, lordship, non-proving of documents. Can a plea be rejected on that ground only?
Whether the judgment indicate passed in the non-proving, on what ground your petition under order 21 rule 97 was dismissed
Simply because we have not produced any document
along with the
along with the petition.
petition?
We have mentioned, lordship trial court has mentioned, we have given a kacha deed. That may be a disputed one. But it has to be decided, lordship. Either maybe by having a preliminary issue, some sort of procedural order 6, order 7, order 8, order 14. Either court have to take 7-11 plea for rejection of a plaint. That has not also been done here, lordship. Court has got only two powers, 7-10, return of the plaint, 7-11, rejection of the plaint on some grounds. So that must be at least minimum calling for the respondents. Notice, issuing notice to them, calling their objections, let them file an objections, and then preliminary issues, whether plaint is maintainable on law points. That may be there, lordship. But trial court has to do this. This point has very categorically cleared by lordship in the case of Brahmadev Chaudhary, Honorable Supreme Court of India.
Then this is not a substantial question of law. It has been settled.
No. Whether a suit can be decided this manner in even.
Suit means whether
Guwahati High Court, lordship.
an application, a petition under order 21 rule 97,
Lordship.
whether, no, the substantial question of law which you are proposing
Yes, lordship.
is that whether an application under order 21 rule 97/99
Yes, lordship. We have mentioned it. We have annexed the petition here also, lordship. And that is the judgment here, lordship. Even our High Court, Honorable Guwahati High Court, long back in 1990, lordship, Tapan Sarkar versus Sukilpa Boro.
what has been held?
Just correct. That it has to be like a suit, not by.
So this question is settled question.
It
that
cannot be
we-
decided in limine. A
That is
petition
also
under
a settled.
2197 Cannot
No,
be decided.
you
in
are
limine.
not. I'm on another line.
Lordship.
Mm, Your regular second appeal may be admitted if it involves a substantial question of
Yes,
law.
lordship.
Substantial question of law is a question which I understand, which is not settled.
No, that's why trial court, our another,
Perversity is your
yes, whether the findings of first appellate court are perverse, we have mentioned the substantial question.
ignoring the settled proposition of law.
Those settled proposition of law, lordship, that it has to be tried as a suit. But learned trial executing court as well as the learned first appellate court have not considered these parts.
Okay, where is, do you
Where-
have any authority to support the contention?
Yes, lordship.
When, listen to my query. When a settled proposition of law is not followed in deciding a case, it amounts to perversity. Do you have any authority to support that?
Lordship, it is because I have some remedy, I cannot be remediless, lordship. When a first trial court, executing court, or the first appellate court has not followed the law, itself is a perversity, lordship.
Yes. Heard Mr. S.K. Poddar, learned counsel for the petition, and learned counsel for the appellant. this appeal under section 100 read with order 47 rule 1. Oh, sorry, read with order 42 rule 1 of the Code of Civil Procedure has been preferred by the appellants, by the appellant impugning the order passed in impugning the order dated 18/7/2025 passed in Miss Appeal number 1/2025 by the Court of Learned Civil Judge Senior Division Morigaon, Assam, whereby the appeal was dismissed and the order dated 8/1/2025 passed by Learned Civil Judge Junior Division in Miss J case number 230/2024 in connection with title execution case number 9/2011 was upheld. Stop. After hearing learned counsel for the where is your petition under order 21?
It is at page 21, Lordship.
After hearing learned counsel for the petition, learned counsel for the appellant, and after going through the materials available on record, following substantial question of law is formulated in this regular second appeal. Whether the impugn order of the first appellate court as well as the order dated order dated 8/1/2025 passed in Miss J case number 230/2024 by the executing court, that is the Court of Learned Civil Judge Junior Division number 1, is perverse in as much as it did not follow the procedures to be procedures applicable for deciding a suit while deciding the petition filed by the present appellant before the executing court under order 21 rule 97 to 101 read with section 47 of the CPC. Only this.
Cover, Lordship.
Stop.
Any other question, maybe one window with kept open, Lordship, any other substantial question at the time of final hearing? Lordship?
Law it keeps it open.
Okay, Lordship.
The issue notice to the respondents. The appellants shall take steps for issuance of notice upon the respondents by speed post within 7 days from the date of this order, returnable on 28th of November 2025. Let also the records of Miss Appeal number 1/2025 as well as records of Miss J case number 230/2024 in connection with title execution case number 9/2011 be called for from the executing court. List this matter.
We have a prayer for stay of the execution further. Lordship, otherwise we will be evicted from that. So this petition will be,
IA is there.
no, we have made same prayer, in the same petition, we have made a prayer at page 14, Lordship. In our appeal memo.
Prayer under. You have to file a separate IA
May not be, Lordship.
under
Because-
order 41
because
rule
41,
5.
55 Practically of a decree, here is it is an order only. Have
No,
purported decree.
you are going
have a
for
purported
stay,
decree, Lordship.
stay of execution of the decree.
Just for next, otherwise we will be evicted, the entire matter will be frustrated, Lordship.
No, but for that you have to file an interlocutory application.
But it is the power of the court, Lordship, it can be. Lordship.
Power is always there,
Lordship.
but you
My
have
humble
to,
request, at least till next date or till 7 days, we may file a petition, Lordship, otherwise. the
No,
entire
then
matter
what
be
will-
frustrated, Lordship.
what will happen to the procedure which are laid down by the rules?
Filing of a separate IA,
Yeah.
Lordship, may be there. But once we have made a prayer here, Lordship.
You
Because if a
can,
prayer have to be made, we have made a prayer, Lordship. Because the need is only to make a prayer, Lordship, requesting the court, we have make a request, Lordship. Otherwise, the entire suit will be first.
no, you file a separate IA. You can file it today also.
Otherwise, my entire appeal will be frustrated, Lordship.
No, whether there is a requirement of filing an
I-
interlocutory application for stay,
No, stay, because 41 says. no
because
separate-
100 does not provide for stay.
No, it is 41(5).
This
Power is
appeal
there.
is,
Rules are purely of handmaids of justice, Lordship, not to be for the justice system. Because we have made a prayer.
no,
might
but
have committed
there is
mistake, I don't know
no,
what.
no reason why you cannot file an
No,
IA.
I can file, Lordship, but till interim.
Then
Lordship.
follow the law. Then follow the law. You file an interlocutory application. There is no bar, there is no impediment on your part.
Lordship. And
Had there been a difficulty in filing IA, that
Will-
could
will-
have been understood.
within day or two will.
Okay.
take care.
You are at liberty to file.
Same matter is there, Lordship, same trial court order is of the same date. Appellate court order is of 5 days back. Here is the case of that. We are possessing the land since the days of forefathers. The two of our brothers, the defendants in the suit, it is an expertise suit, Lordship. They have obtained an expertise decree against 2 persons only. Knowing fully well that land is possessed by 7 persons, inherited from their forefathers. Out of 4.5 bighas of land here in this section, Lordship.
Here, where is the impugned order?
Impugned order is at Lordship 43. Same order, same region, Lordship,
Okay,
even by same court on the same date as of the earlier one.
okay, almost same order,
Same order.
same order.
Appellate court order is also same, it is after 5 days only of the first order, Lordship. It is in the
Da-
43.
Date of order is also same.
Trial executing court date of order is same.
And appellate,
Appellate court after 5 or 7 days, Lordship, this is on 24/7, Lordship, appellate court order.
order
Same
from this
court
now.
order, Lordship.
Impugn order is 24/7/2025. Case number Belegovo. Yes, I will make changes. Same order,
Yeah, okay,
same date.
Lordship. We will filing the IA, Lordship, within day or two.
Finding item 24.
May it please your lordship. I'm sorry, I got stuck up in another court. So yesterday, your lordship's query was that, responding to my learned friend's submission, that whether the subsequent event of sending a draft agreement will eclipse the right of bona fide requirement.
Yes.
That was your lordship's query, my lord. Now, if I take your lordship to the sequence of events, my lord, I would rather say that it is
Note लिखा paper में। पुतुल, on drawer আছে। Yes,
I would rather say that, my lord, it is not a subsequent event. The reason is this, my lord, if your lordship will kindly remember what the learned First Appellate Court has recorded in page 109. Learned First Appellate Court in paragraph 35, last 3 lines. The finding is that, my lord, this tenancy agreement, the idea of renewal of the tenancy agreement, has your lordship got it?
yes. 109,
Yes, last three sentence of paragraph 35.
yes.
The idea of renewal of the tenancy agreement with the defendants, but this proposal was sent prior to filing of the suit, and the plea of bona fide requirement cannot be negated on this ground. So this was contradicted yesterday by my learned friend by referring to the cross-examination of the PW1, where she admitted that she had sent a draft agreement to the son of the defendant number 2.
After filing of the suit.
They say it is after.
That
filing
is
of
his plea.
his
That is,
plea, but it is not. That's why yesterday also I got little confused because the sequence of events would tell otherwise. If your lordship will kindly see the page 31.
31.
Yes. Page 31 is the copy of the plaint. And the affidavit sworn in support thereof.
Yes. 31 is the affidavit.
Yes. Now this affidavit was dated 23rd of August 2013. And if your lordship will kindly see the page 23, the endorsement by the Serestadar is also of 23rd August 2013. Meaning thereby the filing of the suit was on 23rd of August 2013.
Yes.
Now, if your lordship will now kindly see the statement of the defendant in the written statement, that will be at page 39. Page 39, last 4 lines. The defendants started depositing rent in court. And in the month of
No,
September,
where are you reading?
last 4 lines, beloved,
Page 39.
page 39. In the month of September 2012,
Yes, the defendant.
yes.
The defendant state that.
Started in the month of, defendants started depositing the rent in the court in the month of September 2012. A mutually understanding was arrived at between the plaintiff and the defendants, and the defendants agreed to enhanced rent from rupees so-and-so to so-and-so, and thereafter a draft lease agreement was sent by the plaintiff to the defendants, and since this says draft agreement was not as per the mutual understanding,
Yes.
arrived at between the plaintiff and the defendants, and in the said agreement, the plaintiff had demanded further advance of rupees so-and-so and wanted to enter into agreement with the son of the defendant number 2 and not with the defendants, which was not acceptable to the defendants, and as such the agreement could not be signed. So Exhibit C, which has been referred to by my learned friend, that was only a draft deed, not acted upon by either of the parties, and that was a document which was prior to filing of the suit. To be precise, 1 year prior to filing of the suit, approximately.
How can you say so?
Now, if you will kindly see the Exhibit C, yesterday he had shown Exhibit C is dated 1st October of 2012. Yes, sir. Sir, your lordship will kindly see the date. It was 1st October of 2012.
When the suit was filed, 23/9,
23/9/2013,
Mm,
almost 1 year after this draft agreement was drawn. So therefore, the finding of the learned appellate court that the agreement was prior to the filing of the suit and not a subsequent event, well, that is not incorrect.
Okay.
This is one aspect of the matter, I mean, on facts. Otherwise also, my lord, although, my lord, that the submission that I'll make now perhaps will not be necessary for the purpose of this case, but still, my lord, since your lordships had put the query to me, my lord, I'll try to answer it. Now, assuming for a moment that this agreement was indeed a subsequent development, then what would be the consequence? Will it eclipse the question of bona fide requirement?
Yes.
My lord, the judgments that I place before your lordship, my lord, it says, and just in tune with what was the observation of the learned first appellate court's judgment, that the bona fide requirement has to be assessed on the day of the filing of the suit. And the subsequent event can play some role if and only if it is so that which will change the nature and character, the dimension and consequence of the case entirely. Now, this is a scrap of paper, I would say, because it is neither acted by the plaintiff nor the defendant. And this was also drawn much prior to filing of the suit, approximately 1 year prior to filing of the suit. So therefore, the finding of the learned first appellate court that this will not negate the claim of bona fide requirement because it has to be adjudged on the day of filing of the suit. So far as the merit of the claim is concerned, well, the evidence of the plaintiff has been gone into by the learned first appellate court, and that could not be dislodged by the defendants on the point of bona fide requirement. The only plea that they took to dislodge the claim of bona fide requirement is that there was an agreement, attempt to enter into an agreement.
Exhibit C.
Exhibit C. And that was also their case in the written statement. In the written statement, if your lordship will kindly see, their statements will occur at page 38, paragraph 15. Now, I read from paragraph 39, page 39. Well, actually, it is paragraph 15, which starts from page 38. And in page 39 itself, they have said that about 10 lines from bottom, which goes to show that the plaintiff has no bona fide requirement of the tenanted premises. In fact, it is the modus operandi to file the suit, force the tenant to agree to pay enhanced rent as per her demand and also salami, etc., etc. So it was their plea. So therefore, the learned first appellate court has correctly held that this will not influence the filing of the suit on the ground of bona fide requirement, which is about after a year of the said deed.
Okay.
This is my submission on the facts bill. And the decision, my lord, that even if, my lord, for a moment it is assumed that it is indeed a subsequent event. Now, your lordship may kindly see this decision. May kindly see paragraph 13 at page 610. In our opinion. In our opinion, the subsequent events to overshadow the genuineness of the need must be of such nature and of such dimension that the need propounded by the petitioning party should have been completely eclipsed by such subsequent events. a three-judge bench of this court in so-and-so versus so-and-so, which pointed to the need for remolding the reliefs on the strength of subsequent events affecting the cause of action in the field of rent control litigation, forewarned that cognizance of such subsequent events should be taken very cautiously. This is what the learned judges of the bench said then. Well, thereafter, the court is there. We affirm the proposition that for making the right or remedy claim by party just and meaningful as also legally and factually in accord with the current realities, the court can in many cases must take cautious cognizance of events and developments subsequent to the institution of the proceeding, provided the rules of fairness to both sides are scrupulously obeyed. Now, that is not the case here, of course, but the subsequent event is also not the case. Practically, it is a case where the alleged transaction had taken place much prior to filing of the suit. So on this ground, the finding of the learned first appellate court cannot be dislodged. And even if it is assumed for the sake of argument that this is a subsequent agreement, which actually it is not, well, it does not have any effect, so to say, because neither it is an agreement.
It is not an agreement, it is a draft.
It is a draft. And it is not agreed upon by the well, to become a valid
His
agreement.
submission is that your act of sending a draft agreement itself shows that you no longer require.
That
That is his submission.
yes, that was in 2012. That was in 2012. The suit was filed in the year 2013. After 1 year, almost after 1 year, because it is dated 1st of October, suit was filed on 23rd of
And
September.
when the exhibit C was handed over to you,
Lordship,
when it was sent to you.
no, their case is that it was sent by me to them.
Yes, sorry, when you sent it to
So
them,
it is October, 1st of October 2012.
where is the date mentioned?
Date is on the exhibit itself.
No, date, apart from the date mentioned in the exhibit C,
They are in the
is there any
evidence-
statement on so and so date?
No. In the, because this has surfaced only during cross-examination by the defendants.
They've admitted it, my lord.
This
They've
has, sur-
admitted.
yes, this has
Even if it
surfaced
is-
only during the cross-examination by the defendant. And they did not.
Whether in cross-examination, he admitted that it is after the filing of the suit.
No,
It is, yes, my lord.
no,
Ju-
This is
Just,
the deposition. This is the.
just a
admission.
minute, I am interrupting for a while. Yes, Mr. Jalan, where it is mentioned?
Yes, sir. Bro,
137.
Page 146, my lord, the certified copy I will take a look. The defendant sent one, my lord, 146 of my
Yes.
additional affidavit, my lord.
Yes, yes,
In the middle, third paragraph, fourth paragraph, my lord.
yes.
The defendant sent one draft tenancy agreement regarding renewal of the tenancy, stating several terms and conditions of the agreement, which was not agreed by me after filing of this present suit. This is categorical. And I have sent a draft lease agreement. The natural corollary and the interpretation would be, my lord, firstly, the defendant tenant has sent, which was not agreeable by the landlord.
No, but
In-
when
in
I
taxi
have,
sent,
yes, I have sent a draft lease agreement to defendant without,
was not agreed by me after filing of this present suit. This
no,
is clear admission.
you
my
are
lord.
not relying on that paragraph. You're relying on the subsequent paragraph that I have sent
Yes, I have sent a draft lease agreement to the defendant without any signature.
when.
That is not mentioned, my lord, but still only the interpretation which can be, that cannot be. You have made a
Okay,
submission. please.
Okay, no,
Since firstly, I have sent, which was not agreed upon by the
okay,
landlord.
what is your submission? You may continue.
My lord, another aspect.
You may, you will get chance to reply.
Now, he says in the cross, that she says in the cross that the defendants had sent me an agreement. And when.
After filing of this suit.
No, I did not agree to the terms after filing of the suit. Sending of the agreement is not after filing of the suit, because if your lordship will compare this statement with the statement in the written statement, your lordship will kindly come back to paragraph, page 38.
Okay, which was not agreed
Yes,
by me after filing of this.
after filing of this suit, I did not agree to it. Now, your lordship will kindly see their statement in the written statement. How they have qualified it. They have said that in the month of September 2012, a mutual agreement was mutual understanding was arrived. So it cannot be that after filing of this suit also they sent an agreement. It is not their case. There-
Read the next para. I have sent.
Yes, I have sent a draft lease it ought to have been I had sent, but anyway, I have sent a draft lease agreement to the defendant without any signature. Exhibit C is the draft lease agreement sent by me.
When it was sent.
That was for them to elicit the answer.
Is that it was sent after
That
filing
it
of.
was sent after filing of the suit. They cannot now join the line to say that it was sent after filing of the suit. And practically,
Okay.
Milord, at this revisional stage, this reappreciation of evidence to this extent is not permissible.
Yes,
Only if your lordship have to see that whether the finding by the first appellate court is within the parameters of law or not. Now, he challenged the finding on the ground that the finding of the trial.
no, one of his plea was that the observation made by the first appellate court that it was sent, the notice was sent prior to the draft exhibit C was sent prior to filing of suit is perverse.
That was his submission, but that
Yes.
is not borne out by the records.
Okay.
That is not because.
Because there is no indication as to when.
His pleaded case in the written statement tells otherwise. In written statement, he says that I filed the agreement about which there is a disclosure by the PW1 that I sent a agreement in the month of September 2012, and thereafter the draft agreement was sent by the plaintiff to the defendant. If your lordship, if I may read out the last sentence of the
WS.
page 39 once again. In the month of September 2012, a mutually understanding was arrived at between the parties, plaintiff and the defendants agreed to enhance the rent from so-and-so to so-and-so. Thereafter, a draft lease agreement was sent by the plaintiff to the defendants, and since in the WS also he does not say that
When?
it was sent after filing of the suit.
Okay.
So, naturally, the interpretation would be, it will have to be on a date prior to filing of the suit. And since he doesn't say anything in the WS, he cannot now put words in my mouth that it was sent after filing of the suit. So this is one aspect. Secondly, which I have now cited, there has to be complete eclipse. Then only that subsequent event can be taken into account.
Okay.
I can understand, my lord, the complete eclipse would have taken place had this agreement been acted upon by the parties. Had this draft transaction, whatever was drawn.
Or the agreement was not executed.
Yes.
Nobody has signed.
Nobody had signed, neither he nor did I. So it's a scrap of paper. It's no agreement at all.
Okay.
And this particular judgment, the Gaya Prasad case, which I have just now cited, this was recently referred by Honorable Supreme Court in a recent decision, Miller, and the same view has been reiterated with India. Same view has been reiterated, and your lordship will also kindly consider one aspect, Miller. Suit was of 2013. For last 12 years, they have been occupying the suit premises. And this was noticed in the Honorable Supreme Court's judgment that how, because of the length of the proceeding, the situations are naturally to take development, but that cannot entitle the defendant to take a plea that there is complete eclipse. Yesterday, I also came across a case where a question of eclipse of bona fide requirement was asked in view of the fact that the plaintiff had died. The Honorable Supreme Court said death of the plaintiff will not be considered to be a relevant subsequent event to negate the plea of bona fide equivalence, because it has to be judged on the day of the filing of the suit. And the
Okay.
same view has been sounded in this judgment also, my lord. Huh? 11 or 10. There are 10 and 11 of this latest judgment, your lordship may kindly also see.
Please read para 11.
It is
Yes,
no
10.
doubt true that as observed by the High Court, the plan for construction and financial capacity to construct has not been placed as evidence. However, as already indicated above, the nature of the requirement as stated by the landlord would be for running a garment shop, which in any event could be run in the premises as it exists with minor alterations, though the desire of the landlord is also to demolish and reconstruct. Therefore, in that circumstance, the mere non-production of the approved plan or the documents to indicate financial capacity at this juncture cannot be held fatal in the instant facts. That apart, as indicated above, the need of the landlord while being examined has been weighed in the background of the fact that the tenant owns 2 other premises and no hardship will be caused. And here also, my lord, the learned First Appellate Court has taken note of subsequent decisions of the Honorable Supreme Court, where it has been laid down that the tenant has to show that he has made endeavor to secure alternative accommodation. If he fails to show that, my lord, a decree of possession will be justified. Your lordship can just see in page 109 of the appeal memo. Relevant observations are in paragraph 38, page 111. The Supreme Court in the case of Murlidhar Agarwal,
Para 30.
38.
Yes.
The Supreme Court in the case of Murlidhar Agarwal versus so-and-so reported in so-and-so, while reiterating its decision in so-and-so versus so-and-so, held that one of the circumstances to be seen while appreciating the comparative hardship is to examine whether the tenant has brought on record any material to indicate that at any time during the pendency of the long drawn out litigation, he made any attempt to seek an alternative accommodation and was unable to get it. This factor will be one of the circumstances to be taken into consideration while determining whether the claim of the landlord is bona fide. In this case, nothing is on record to show that the tenant who has been in the premises for the total of 73 years with so-and-so of them after the expiry of the lease has made any attempt to seek any alternative accommodation, and nothing is brought on record to show that he was unable to get one. It is seen that in the instant suit, the defendants neither pleaded nor showed that they searched for suitable alternate accommodation to shift their place of business after receipt of notice exhibit 4 from the plaintiff, which was issued 6 months prior to termination of the lease agreement, but were unable to get one. On the other hand, the plaintiff pleaded requirement of the suit room for opening up a medical clinic for her daughter, who passed her MD and stated to have no other suitable room except the tenanted premises. Except for the averment that the plaintiff has no intention to use the suit room for opening medical clinic, the defendants did not plead availability of other rooms in the building of the tenanted premises, which the plaintiff can utilize for opening up the medical clinic of the daughter. Thus, in the light of the above judgments and also taking into consideration the pleadings and evidence, this court is of the opinion that the suit room is a bona fide requirement of a family member of the plaintiff. The decision of the trial court on this issue needs interference and it is hereby set aside. So, my lord, in my respectful submission, the finding of the learned First Appellate Court on consideration of totality of the evidence and facts is wholly justified. It cannot be said that it comes within the exceptions carved out in section 115 of the CPC, that the court has acted with material irregularity and wholly illegality has been, or miscarriage of justice has been created. 2013 a notice was 12, a notice was served to you. You have been occupying the room for last so many years. What more do you want? In all the judgments, my lord, that I could place my hands on, the only thing the Honorable Supreme Court and the other high courts have said is that, well, all right. Now the case has been decided. Take 6 months, 3 months, 4 months, vacate it. Recently, your lordship has also must have come across a judgment whether Supreme Court had to take contemptuous action by sending the tenant to jail. Because despite giving an undertaking, he did not obey with the order. So ultimately, it is not your property. You are there on the strength of some agreement, which has long back expired.
This Murlidhar Agarwal's case
Yes,
is in the context of examining the comparative hardship.
yes.
If the owner seeks the suit premises on bona fide requirement,
And
they-
on the contrary, there is no attempt by the tenant
to see,
seek alternative accommodation.
so there is no plea on the part of tenant that he is unable to find an alternative. Therefore, comparative hardship is
In favor of the
Really?
landlord.
okay.
And interestingly, my lord, this part of the observation of the learned first appellate court and the eventual finding, that has not been challenged by them. They do not challenge this finding or observation of the learned first appellate court.
Okay, okay.
Their only point is that
The
subsequent event
requirement of bona fide
is not justified.
is
because-
eclipsed,
Yes, eclipsed because I sent a
exhibit C.
exhibit C. And they viewed it that this exhibit C is after filing of the suit, which in my respectful submission is not correct. Because their
Okay.
plea in the WSS tells otherwise.
Yes, anything. You're done with anything more?
Well, just my friends tells me to submit one
No,
more
if it is
decision
not
below.
required,
Or
don't burden.
these are all, I mean, all almost in the same line below, only one paragraph, paragraph 7. Laying down the similar principle, nothing new. Bona fide requirement of the landlord has to be seen on the date of the petition and subsequent events intervening due to protracted litigation will not be relevant. It was held that the crucial date is the date of the petition. Their lordships further observed that the normal rule is that the rights and obligations of the parties are to be determined on the date of the petition, and that subsequent events can be taken into consideration for molding the reliefs, provided such events had a material impact on those rights and obligations. It was further observed by their late lordships that it is a stark reality that longer is the life of the litigation, the more would be the number of developments sprouting up during the long interregnum. Therefore, the courts have to take a very pragmatic approach of the matter. It is common experience in our country that especially landlord-tenant litigation prolongs for a long period. It is true that neither can the person who has started the litigation sit idle, nor can the development of the events be stopped by him. Therefore, the crucial event should be taken as on the date when the suit for eviction was filed, unless the subsequent events materially change the ground of relief.
Okay, okay.
So practically, my lord, reiterating the same principle. It has to be totally eclipsed, then only he can take benefit of it.
Yes, anything, Mr. Jalan? Any reply?
Your lordship may kindly take the page 25 of the WS. Yes, record upon to the that agreement, draft agreement was prior to the filing of the suit. That is dated 1st of October 2012. Paragraph 25, page 25, paragraph 5, my lord, of my petition. That is the WS. The agreement was for first initial agreement was for a period of, my lord, 3 years. 1/1/2009 to 39/2012. In paragraph 5, my lord, will find of the WS.
Yes.
So necessarily, my lord, now if your lordship kindly peruse exhibit C for a moment, that the draft agreement.
Yes.
So accordingly, this is in line. After 39/2012, this was dated, backdated. 1st October of immediately, the language itself says this lease agreement is extended on this 1st day of October, immediately after 39/2012, my lord. Now that apart, your lordship will in the recital of the lease agreement will kindly see of the draft that exhibit C. May I read, my lord? The premises is on the ground floor of so and so at Panbajar, Guwahati, owned by Mr. So and so, and the second party is in position as a rental in the name of Messrs. Fairdeal. The premise was on rental and the terms have already expired and a fresh lease agreement is made with Vishal Deora for a period of 2 years. This is important, my lord. 1st October 2012 to 30th September 2014. So even if it is taken for a moment that the suit was of 2013, as my learned friend has said, that there is no dispute. But the moment this lease agreement for renewal has been offered, the bona fide requirement no more remains a genuine and honest bona fide. Because they have agreed upon and offered to renew it for a further period of 2 years. Bona fide requirement has to be decided, the plea of bona fide as on date of filing. That subsequent event of offering further extension and renewal of the tenancy for a further period of 2 years itself goes to show that bona fide requirement is no more a genuine and a honest bona fide need.
Okay, subsequent means subsequent to filing of suit.
Yes, and in the deposition, if the DW, the landlord herself has stated that it was sent after the filing and thereafter she has sent.
She has not said
That is
thereafter.
not, that exact word is not there. Because they have not agreed upon, so that is their natural interpretation will be that firstly I have sent which was not agreed upon, then in turn she has sent.
Okay. Okay, heard, Mr.
And I also relying upon 2 judgments, but the judgments which my learned friend has relied upon, their judgments are totally on the bona fide requirement, which plea has been altogether constantly followed till the suit was decided. Here in this case, this exhibit C has waived their right. And I am relying upon 2 judgments, my lord. Ramdas Ishwar Chandra and Pratap Rai. I am also relying upon.
Pratap Rai judgment, that is the last judgment I have
Yes,
cited.
yes.
There it was.
What is bona fide requirement is that I am only upon that, paragraph 6 and 17, my lord. Firstly, your lordship will take Ramdas, paragraph 6. Upon a consideration of the matter, we have the view that both the contestants are in the support of their unsustainable. It is no doubt true that the question whether the requirement of the landlord is bona fide or not is essentially one of fact, notwithstanding the circumstances that a finding of fact in that behalf is a secondary and inferential fact drawn from other primary or perceptive ones. All conclusions drawn from primary facts are not necessarily questions of law. They can be quite often are pure questions of fact. The question as to bona fide requirement is one such. Statutes enacted to afford protection to tenants from eviction on the basis of contractual rights of the parties make the resumption of possession by the landlord subject to the satisfaction of certain statutory conditions. One of them is the bona fide requirement of the landlord, variously described in the statutes as bona fide requirement, reasonable requirement, bona fide and reasonable requirement, or as in the case of the present statute merely referred to as landlord requires for his own use. But the essential idea basic to all such cases is that the need of the landlord should be genuine and honest, conceived in good faith, and that further the court must also consider it reasonably to gratify that need. Landlord's desire for possession, however honest it might otherwise be, has inevitably a subjective element in it, and that desire to become a requirement in law must have the objective element of a need. It must also be such that the court considers it reasonable and therefore eligible to be gratified. And in doing so, the court must take all relevant circumstances into consideration so that the protection afforded by law to the tenant is not rendered merely illusory or whittled down. So the circumstances or as a whole has to be taken into account, your lordship.
Okay.
And paragraph 15 of the next judgment, my lord. This is also almost similar line. Paragraph 15 of the Pratap Rai Tanwani. Recently in Shiv Sarup Gupta versus Dr. Mahesh Chand Gupta, which I have referred yesterday, my lord. This court in a detailed judgment dealing with this aspect analyzed the concept of bona fide requirement and said that the requirement in the sense of felt need, which is an outcome of a sincere, honest desire in contradistinction with a mere pretense or pretext to evict a tenant, refers to a state of mind prevailing with the landlord. The only way of peeping into the mind of the landlord is an exercise undertaken by the judge of facts by placing himself in the armchair of the landlord and then posing a question to himself whether in the given facts substantiated by the landlord, the need to occupy the premises can be said to be natural, real, sincere, and honest. If the answer to be in the positive, then only the bona fide requirement has to be accepted. Because here the man, once, as soon as they have offered the draft agreement for renewal, that bona fide requirements goes. That remains only illusory, just a pressure tactics. And they have stated that they will renew it for an additional sum of security of rupees 1 lakh. So for them, the commercial transaction was more important than their for own use.
Heard Mr. G. Jalan, learned counsel for the petitioner. Also heard Mr. S. Datta, learned senior counsel assisted by Mr. J. H. Saikia, learned counsel for the opposite party. Hearing complete, judgment reserved.
Obliged.
Hearing concluded.
Yes, please, Your Lordship. Lordship, madam will be adjourned for the day because according to last order, we need some more time to get the information. Lordship.
Jurisdiction is there or not?
Yes, Lordship, for that we just need a few more days, Lordship.
Why?
Friday, next week, Monday, Lordship, we couldn't get the information. So on Monday, Lordship, madam.
The query was whether in exercise of power under 24, court can transfer a case to another court which does not have jurisdiction.
My question, if the parties are agreeable, then it
No
can be done
information.
so.
You have to show authority.
Yes, Lordship. Please,
Heard Miss, what is your name? You Nanda, learned counsel for the petitioner. Also heard Mr. K. Kolita, learned counsel for the respondent. Learned counsel for the petitioner prays for some more time to respond to the query posed by this court on 15/10/2025. The prayer is allowed. Let this matter be listed in the next week. In the next week on a on 7th of November, Friday.
what's your question?
Thank you, Mr. Lordship. So this matter is ready regarding service and PCR also been received. We can go for final hearing.
Heard Mr. S.P. Sharma, learned counsel for the appellant. Also heard Mr. S.I. Akan, learned counsel for respondent number 1. As this appeal is ready for hearing, list it for hearing after 6 weeks on a date to be fixed by registry.
Lordship, can it possible at 20 of November?
20 of
November?
after 3 weeks on a date to be fixed by registry.
So.
Then
Condemnation petition, my lord, for condoning delay of my lord 92 days, my lord. First, earlier, the petitioner, my lord, filed a repetition that was withdrawn, my lord. After withdrawing, the communication was done with the petitioner, my lord, and he has some monetary difficulty, it could not come early, my lord. That is why then after coming, this civil revision petition was being filed, my lord. Then after civil revision petition filed, CRP petition filed, the filing sections directed to change the nomenclature, my lord. CRP IA, my lord. That is withdrawn, my lord, then CRP IA filed, my lord. Then after CRP IA file, that was again, my lord, filing section that originally CRP has been maintainable. That was CRP petition file in my file. That is why some delay of 93 days, my lord.
How many days delay?
93 days, my lord.
I leave it to your lordship, your lordship.
You're not opposing.
Your lordship. Only while recording, my objection may be recorded, your lordship. That's it.
Okay. Heard Mr.
Yes, sir.
SIK, learned counsel for the applicant. Also heard Mr.
S.A. Hussain.
S.A. Hussain, learned counsel for the respondent. All the respondents,
Only one person.
all learned counsel for the respondent. Applicants, none. This application under Section 5 of the Limitation Act 1963 has been filed by the applicants seeking condonation of delay of 93 days in preferring the connected civil revision petition by which they have impugned the order dated 30/1/2024 passed by Learned Special Tribunal Gwalpara in LG case number 30/2014. Stop. Where have you mentioned the reasons?
My lord, 9, 10, and 11. Paragraph. First 9, number.
Learned counsel for the applicant has submitted that the applicants were prevented from approaching this court within the prescribed period of limitation for the reasons stated in paragraph number 9, 10, and 11 of this delay condonation application. So, learned counsel for the respondent oppose the prayer for condonation of delay. Stop. I have considered the submissions made by learned counsel for both sides. Considering the peculiar circumstances which caused the delay in filing of the connected civil revision petition by the present applicants, as well as considering the grounds stated in paragraph number 9, 10, 8, 9, 10, and 11 as sufficient ground, this court is inclined to condone the delay condone the delay in filing the connected revision petition, civil revision petition. Stop. Accordingly, the delay of 93 days in filing the connected civil revision petition is hereby condoned. And this interlocutory application is accordingly disposed of. Registry is directed to register the connected civil revision petition and list the same in motion column in the next week on a date to be fixed by registry.
Sorry, my lord, I am division matter one.
It is this.
May it please your lordship. My lord. I am the defendant petitioner here, my lord. A suit was filed by the plaintiff for my lord specific performance contract.
For specific performance.
Performance of contract.
Okay.
So we filed WS and along with the counter claim, my lord. Thereafter, my lord, the plaintiff filed an application for amendment of the, my lord, plaint that your lordship will find that page, my lord,
37.
page 37, my lord. They start from 38, my lord. They, by this amendment petition, they want to add some para and amendment of the pair, and also, my lord, want to add one party. That your lordship got it, my page 37, my lord. That is the application, my lord. And I file an objection also. Page 84, my lord, I file an objection. And my specific plea, page 84, my lord, because I'll, that is short, my lord. Page 84, my lord.
Yes.
Page 84, my lord, para 5. And para, my lord, your lordship kindly see it. I have a specific plea I have taken that it will change the nature and character of the suit. And they try to improve the, my lord, because your lordship kindly see in a specific performance case, the mode of payment is a very important aspect of the matter, my lord. How and what mode he has payment the money. That specifically I am taking a plea,
Where, in which para?
my lord, para 5, my lord. In the said plain, the plaintiff neither the able to show any mode of transaction regarding the sale between the parties, nor the plaintiff stated that any paragraph of the plaint regarding any further document. The plaintiff even did not give any leave of the honorable court to submit the further any document in the regard. That the environment made in paragraph 1, 2, 3, 4, 5 in instant petition are matter of record, and such need not to be comment upon. However, burden lies upon the petitioner to establish the same. 7, that the first 11 numbers of lines of para 5 of the instant petition field word, the counterclaim are matter of record, but in the race environment in the para will be environment para 6 instant petition, the plaintiff want to incorporate new fact and circumstance document cause action in the plain, but same is not permissible.
What
in the
amendment was sought for? What amendment was?
amendment. He want to, your lordship kindly see that para did not, then it will be clear, my lord.
Yes.
The eyes of law, and then after the nature and character of the instant suit will the submit that the present suit is brought up suit for plaintiff is suit for specific performance of contract. But if the proposed amendment is allowed, that will be change the nature and character of a suit for the suit for specific performance of contract to a suit of eviction of the defendant will do other relief. As such, the contract cannot in para 5, 6 and instant petition aforesaid are illegal and not valid. It is submitted that the plaintiff not entitled to any relief as paid for application seeking amendment of so and so, so and so. So when I made a specific allegation, specific that it will change the nature and character of the suit, my lord, not a single line finding on that, my lord, by the impugn order. When I raise a question, at least, my lord, they should be given a finding, my lord. Only, my lord, petition was allowed. I'll come to that, my lord. That it is in within time, so trial was not started, so that is allowed. So regarding, my lord, changing nature and character of this, my lord, that is not a single line, my lord. Your lordship kindly see the impugn order, my lord. He want to incorporate some para, my lord. By that, my lord, he want to add his own son to be party. And some of the document which was not with him, my lord, with his son, and that try to incorporate this, my lord. And but interestingly, that son is the, my lord, he's the in charge of this suit, my lord. He's a representative character. He is the in charge of this suit. The document lies on with him, my lord. Now they are, my lord, want to exhibit here, my lord. Now, my lord, your lordship, I am not on that, my lord. Your lordship kindly see when my question is that when I raise a question specifically, that it will change the nature and character of the suit, my lord. Not a single finding on that, my lord. Now, your lordship kindly see the impugn order, my lord. Page 89, my lord. Today, may I read it, my lord?
Yes.
today has been fixed for order on an instant miss case petition number so and so filed by the plaintiff and the suit number so and so under the rule 6 under order 6 rule 17 order 1 so and so read with the section 151 C2C. Seen the petition, the plaintiff as a petitioner has stated in the petition that on 18/2/2021 the predecessor interest of the defendant, namely Hiteshwar Saikia. Now this is executed, registered, and agreement sale being deed number so and so for in favor of agreeing to sell a plot of land measuring 7 biga 1 katha 17 lesa covered by DAG number 994 Khiraz Miadi Pata number 6 of village body to so and so. The Golaka total consideration amount of 50 lakhs one, and out of which the petitioner paid a sum of rupees 48 lakhs, which the seller Hiteshwar Saikia acknowledged the receipt of the same. Thereafter, though the petitioner was willing to pay the remaining balance amount of 2 lakhs one, that was the execution of the final sale deed, and of course the seller Hiteshwar Saikia several times, but the seller delayed and obtained the sale commission of the execution of the final sale deed on one or other pretext. The meantime, on 25/2021, the seller Hiteshwar Saikia died, and so the petitioner on 7/8/2020, and thereafter several times opposed the opposite party number 1 to 4, that is a legal hierarchy, said Hiteshwar Saikia received the balance consideration and request them to obtain a NOC for the sale to execute the final sale deed, but to adopt the delay in practice for the which the petitioner on 2/2/2023 issued a legal notice on the opposite party, since the opposite party turned deaf ear to the request of the petitioner even after the issuance of the legal notice, that the petitioner filed his title suit for specific person of the contract. The opposite party number 1 to 4 contested the suit by along with the counter claim for declaring that the agreement dated 18/2/2021 is void, and for the cancellation of the same, the opposite party number 1 to 4 contended that their predecessor in interest never received any money from the sale of the suit land from the petitioner, and the petitioner did not show the mode of transaction in the regard. The challenge the counter claim, the petitioner stated that the said deed was valid document, being a registered deed and cannot be cancelled. The petitioner stated that the para 6 of the claim that he has stated that the taking possession of the suit land, the plaintiff fenced the entire schedule of the land around the bamboo fencing instead of install a crusher machine and made some type house has been possessing the said land peacefully. On the contrary, the opposite party, their written statement had counter claim stated that they are possessing the suit land since long, and the plaintiff has no right to dispose them. The petitioner contended that after filing the TS number 11 of 2023 on 24/6/2023, when Nandu Tanti, the staff of the plaintiff came back after going out from the suit land on 10 AM. They found that the gate of the suit land locked, and defendant number opposite did not allow the staff to the plaintiff to enter in the suit land. Thereafter, due their dire constriction at the time of petitioner, plaintiff was out of the station and returned and filed a FIR for this aforesaid incident. However, in this way, the opposite party disposes the plaintiff from the suit land and took over the control of the stone crusher machine business and the suit land. The plaintiff has been recently handed over a certain document by the son of Govinda Kumar Sodhori and Ajoy Kumar Sodhori, which were misplaced in the fact emitting from the same minute of incorporated in the plain, and such the necessary amendment are required that the plaintiff, since the said document were executed by seller Hiteshwar Saikia and are related to the land stones crusher business, and the proposed amendment to the plaintiff there followed. That the end of the paragraph 6 of the plain, the following lines are required to be inserted, but on 26/6/2023, when the staff of the plaintiff, namely Nandu Tanti, who have been residing over the suit land, went to the about 10 AM, and after some time when they came back to the found to gate of the suit land was blocked, and inquiry by him, he came to know that the defendant had locked the gate. The defendant did not allow the staff of the plaintiff to enter in the suit land, and then thereafter threatened him with the dire consequence. At the time of plaintiff was out of station, and so far her staff could not inform the plaintiff immediately, and to her return after a few days, the plaintiff filed a FIR before the concerned police station, that is Dergaon Police Station, regarding the same incident, and stated that this way the defendant illegally disposes the plaintiff from the suit land and took over the control of the stone crusher machine as well as the suit land from which possessing the possession of decree or specific provisions of contract. The defendant are required to be directed to hand over the possession of the suit land into the plaintiff, and on their failure to do so, then the predecessor of the land required to be recovered from the defendant through the intervention of the suit honorable court. The insertion of the said line, the first part of the said paragraph 6 of the plaint would also appear as follows. That after taking the possession of the schedule mentioned, the plaintiff forced fence entered the schedule land and around the bamboo fencing, installed the closing crusher machine, the made small Assam type room from the purpose of therein, and has been possessing the said peacefully and uninterruptedly. Since then, but on 24/6/2023, where the staff of the plaintiff, namely Nandu Tanti, who has been presiding over the suit land, went out of the 10 a.m. after sometime when they came back, found the gate the suit land was locked, and on inquiry he came to know that the defendant and locked the gate. The defendant did not allow the staff of the plaintiff to enter in the suit land, and they threatened him with dire consequences. At the time of plaintiff was out of station, as so that his staff could not inform the plaintiff immediately and to return after a few days. The plaintiff filed an FIR before the concerned police station, that is Dehgaon Police Station, regarding the some incident. It is stated that this way the defendant illegally disposes the plaintiff from the suit land and took over the control of the stone crusher business, as well as the suit land and other. On passing the decree of the specific performance contract, the defendant are required to be directed to be handed over the possession of the suit land to the plaintiff, and to their failure to do so, then the possession of the land is required to be recovered from the defendant for the intervention of the honorable court. 2. That the sub paragraph in this the sub paragraph is required to be amended. It will be added the paragraph 6 in the following manner, by which stated that through the stone crusher business was originally started by Hiteswar Saikia in the year 2012, but could not run the said business, from which the 4/2/24 he had to lease out the said business. Sri Ajoy Kumar Chaudhary, attorney of the plaintiff, for a period of 3 years by executing an agreement for lease, being the deed number so and so, and also did the specific power of attorney deed number so and so in favor of the lease. Sri Ajoy Kumar Chaudhary, on expiry of the lease that in the year 2017, Hiteswar Saikia tried to run the stone crusher business for few years, but eventually ran into a financial problem, and then the year 2020 approached the Sri Govinda Kumar Chaudhary, pro forma defendant number 5, to sell the stone crusher unit, and then connection entered in the agreement for sale dated 17/8/2020, registered on 18/8/2020, where the Sri Hiteswar agreed to sell the stone crusher unit to Govinda Chandra Chaudhary at the total consideration of rupees 15 lakhs, and out of which the considered amount of received rupees 14 lakhs were advance money from the Sri Govinda Kumar Chaudhary, with the further understanding that the balance consideration amount of rupees 1 lakh would be paid at the time of registering the sale. The said Govinda Kumar Chaudhary, performer defendant number 5, had made the huge investment of money in the stone crusher business, that he in the intention of to eventually purchase it from the Hiteswar Saikia, but he also encountered some financial problem, and the Hiteswar Saikia was faced with the situation that he could neither run the stone crusher business himself nor maintain the property suit land, and they decided to sell the entire property along with the things attached to them to plaintiff, a total consideration of rupees 50 lakhs. And thereafter, after receiving an advance amount of rupees 48 lakhs from the plaintiff, then thereby acknowledging the said advance amount of 48 lakhs entered into the agreement for sale, being deed number 48 dated 12/2/2021, registered on 18/2/2021, with the plaintiff, where it was agreed that the balance consideration amount will be paid by the purchaser, the plaintiff, at the time of registering of the sale deed. It is further stated that at the time of execution of the agreement for the sale, understanding was arrived at between seller Hiteswar Saikia and the plaintiff and her son Sri Govinda Kumar Chaudhary, performer defendant number 5, that Sri Hiteswar Saikia would settle the amount in respect of the investment made by the Govinda Kumar Chaudhary, performer defendant number 5, the stone crusher business, from the sale of proceed received from the plaintiff. The said it is stated that for the purpose of selling the land, the seller, Sri Hiteswar Saikia, has also executed 2 separate deed and general power of attorney, that is one of the land and another is the stone crusher business, in favor of the performance defendant number 5, namely Sri Govinda Kumar Chaudhary. The deed of general power of attorney which was in respect of the land was registered at deed number 49, dated so and so, and the said fact is duly mentioned in the agreement sale being the other deed general power of attorney which was for the purpose of stone casa business was registered as the deed number 50 of dated so and so, where the clause 19 of the said deed it is mentioned that the execution of the shall not be complete to revoke sign alter are made on the inevitable the power of attorney as backed by agreement, and attorney has put huge financial also to the said business. It is stated that after execution of the agreement for the sale on 12/2/2021, it was registered on 18/2/2021 and taking over the possession of the suit land by the plaintiff. The plaintiff and now had to make fresh installation in the stone casa business together with the setting up a office room in front of Assam structure and was peacefully possessing the suit land and running the business. But on 24/6/2022, when the staff of the plaintiff, namely Nandu, was the victim residing over the suit land, went out to the suit land. After some time, when he came back to the found the gate of suit land was blocked, and inquiry by him, he came to know that the defendant had locked the gate, and defendant did not allow the staff of the plaintiff enter in the suit land and threatened him with a direct consequence. At the time of the plaintiff out of the station, he had could not plaintiff immediately on her return 2 days after the FIR and the Derga police station, it is so stated. Before disposing the plaintiff on the suit land and took over the control of the stone casa business as well as suit land after the while she's passing the and decree for specific person conflict, the defendant are required to be direct to be in hand over possession of the suit land to the plaintiff, and to their in failure to the do so, then the possession of the land is required to be recovered from the defendant through his intervention of the honorable court, and the plaintiff is required to be put in possession of the suit land. In the pair portion of the plaint after pair number, the following pair is to required to be added in the pair number 1A in the following name. 3A, directing the defendant to deliver the possession of the suit land to the plaintiff, and on their failure to do so, then the same may be recovered by evicting the defendant therefrom, and plaintiff is put possession of the suit land. That if the document filed along with this application and the fact arising there from is taken into consideration, then Govinda Kumar Chaudhary became a necessary party for the proper determination of the suit land. Hence, the said Govinda Chaudhary is required to be implemented as a performance defendant number 5, and his name is required to be inserted in the cause title so and so, to Govinda Chaudhary so and so. The performance defendant, the plaintiff petitioner plaintiff submit that the aforesaid proposed amendment will not change the nature and character of the suit. Rather, the same is necessary not only for the enable the petitioner plaintiff to effectively fight her case before the court, but also determining the dispute by the court involving the concerned suit land. Under the circumstance, the petitioner plaintiff paid allow the plaintiff to amend the name, manner and stated here, paragraph 6, and the instant petition and the related document in the suit. Also allow the plaintiff to implement the Govinda Kumar Chaudhary in a performance defendant number 5 in TS number 11 of 2023, and pass such other order as your deemed fit and proper, pending disposal of the instant application to stay the further proceeding of the TS number so and so. The opposite party defendant filed their written objection against the instant petition of the plaintiff petitioner. In the written objection, the opposite party stated that there is no cause of action filed in the instant petition against the defendant. That the instant petition is not maintainable both in law as well as in fact. That the plaintiff has not came with a clean hand to get any relief from this court. That the plaintiff also filed an instant suit for specific performance, and defendant contested the suit by filing their written statement and counterclaim that in the said plaintiff neither able to show mode of transaction regarding the sale between the party, nor the plaintiff stated any paragraph of the plaint regarding any further document would be plaintiff. The plaintiff even did not even crave leave of this court to submit further any document in this regard. That the averment made in para number 1, 2, 3, and 4 of the instant petition matter of record, and as such a burden lies upon the plaintiff to establish the same, that the first 11 numbers of lines para 5 of the instant petition till word counterclaims are matter of record, but in the rest averment in the para will be in the averment of the para 6, the instant petition. The plaintiff want to incorporate new fact and circumstance document cause of action in the plane, but the same is not permissible in the eyes of law as the same cell did lead the scenes and alter the nature and character of this instant suit. It is submitted that the present suit is plaintiff is suit for a specific performance of contract, but the proposed amendment is allowed that will change the nature and character of the suit from the suit for a specific performance of contract to a suit for eviction of the defendant with the other relief. As such, the content in para 5 and 6 contents in para 5 and 6 of the instant petition as aforesaid are legally not valid. That the government para 7, 8 of the instant petition are shortly denied. It is submitted that the plaintiff is not entitled to any relief as paid for the application seeking amendment of the plain should not be allowed under Order 6, Rule 17 of the CPC. If the amendment in altered change the nature and character of the suit, that as the instant petition seeking amendment of plain is not permissible in the eyes of law, remaining relief for adding the defendant number 1 under Order 1, Rule 10.2 of the CPC is devoid of any merit, that if the court allows the plaintiff to amend the plain, then the defendant shall be highly prejudiced. Under the aforesaid circumstance, the opposite party dismiss the instant miscase with the cost. Till then, my lord, these are all fact, my lord, submission of both the parties. Seen the petition, now your lordship kindly see. Heard both sides. On perusal of the record, it is seen that instant connected suit was filed on 27/4/2023, where the plaintiff on his basis of agreement for sale deed on 12/2/2020 and such specific performance of the contract. The defendant further perusal of the record, specifically in the plain, reflected that the plaintiff pleaded about the payment of earnest money amount of rupees 48 lakhs in the advance amount of the total sale consideration of the petition, along with the consequent taking possession of the suit land facing the same installation of the crusher machine, construction of the Assam type house of the office, etc. Further peruse the record shows that defendant filed their written statement and counterclaim pleaded regarding their possession of the suit land. The plaintiff in the instant amended petition asserted about the disposition of the defendant on 24/6/2023 and also about the discovery of a new document regarding which he had stated to have no previous notice, as those were the possession of the son of his Ajoy Kumar Sodhori and Govinda Kumar Sodhori, and also asserted that Govinda Kumar Sodhori has to be implemented as a suit of the just and proper of the adjudication. Under Order 6, Rule 17, CPC laid down the provision for amendment of pleading, and it stated that the court may at any stage of the proceeding allow their either party to alter and amend the pleading in such a manner and such terms may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question of the controversy between the parties, provided that no application for amendment shall be allowed after the trial's commence, unless the court came to the conclusion that in spite of the party would not have raised the matter before the commencement of the trial. It is clearly seen that the provision of law allow the parties to amend their pleading at any stage of the proceeding before amendment of this trial, before commencement of the trial. The case record reflected that the instant petition is filed when the suit is posted for filing a written statement against the counterclaim in the defendant, and as such the trial of the connected suit has not commenced yet. Considering that the facts asserted to be inserted in the pleading of the plaintiff, it is a subsequent development after filing the suit, and the trial has not commenced yet, such the prayer for amendment is allowed. But the question which I was raised, your lordship kindly see only one para. They have stated that yes, it is within time, it is before commencement of trial, that is why it is allowed. But I raise a specific question that it will change the nature and character of the suit, because specific performance case is now converted to a my lord eviction suit. But at least, my lord, when I raise the question that my lord, that specific finding should has been given, my lord, it is not there, my lord. Now, my lord, your lordship kindly see what document he want to annex, my lord, which are in his possession of his son. And his son is who, my lord, who represent the case, my lord. He has a representative character. So that is within their knowledge before the trial, my lord. Before the my lord filing the suit. Your lordship kindly see the plaint, my lord. The plaint is page 15, my lord. Page 15, my lord. Page 15, my lord. Srimati Rama Devi Sodori is about 79 years, wife of late Anjani Sodori, resident of Nomoligarh Tea State, post office so and so. He is represented by the attorney of Sri Ajoy Kumar Sodori, son of late Anjani Kumar Sodori. So now he want to annex some document which was in possession of that Ajoy Kumar Sodori. But there is no averment made in the plain that, my lord, some of the document, my lord, at the time of due course, it will be submitted. There is no any averment, my lord. Now, my lord, your lordship kindly see, they want to, my lord, fill up the lacuna, and my lord, they convert it to the, my lord, ejection suit, my lord, eviction suit, my lord, because of the, probably that is the subsequent event, my lord, but whether that will be another trial, my lord. Now, my submission before your lordship, when I raise a question that there is a specific plea that nature and character will be sent, there is no finding on that one. That is why I am visiting the division I find. Thing is that order.
Yes.
May I
So,
please, Your Lordship?
may I please
Anything.
find that?
If nature and character changes, amendment cannot be allowed.
My lord, a prayer for amendment is generally required to be allowed unless by the that is judgment of my lord. The very recent judgment of 20 decided on 2022, my lord. It is
The-
2022 16 SCC 1. I'll
One,
give a copy.
no, before that one query. The act of dispossessing you is subsequent to the filing of claim.
My that is their alias, my lord. But there, when I specifically I have taken, it is already in my possession, never be in their possession, my lord. That is, my lord, already I filed a WS, my lord. I have categorically stated it was all along it was never been in their possession. When it is not never been in their possession, how they can not dispossess, my lord? So that is, my lord, just try to improve the case, my lord. And my lord, your lordship kindly, what they say in this judgment, my lord, the amendment change the nature of the suit. That cannot be allowed, my lord. The prayer for amendment is malified. So here in my lord, your lordship kindly see, in a malified intention, my lord, filed his amendment petition, my lord. Your lordship kindly see what he want to annex, my lord. Some document he want to annex, who is here in his possession of his son, my lord, who is representing his case, my lord. In the plain, my lord, there is no any averment. The sum of the document will left, we did not allow, due course will submit.
No, in the amendment petition, they have stated that it was later on traced out.
My lord, that is, my lord, later on case out, my lord, this is if it is a, my lord, required document to that, my lord, then why they have not done it in, my lord, prior to that, my lord? So there, when that way, my lord, they want to improve it, my lord. It's a malified intention, my lord. That is my submission, my lord. And second submission is that, my lord, when I raise a issue that has to be answered, my lord, by the trial court, my lord. Not a single line, your lordship, kindly, just because, my lord, it is within time, that is allowed. That cannot be, my lord. Your lordship kindly see only one paragraph, my lord, they have learned trial court, my lord, quote the order, quote the sections, my lord, they say it is within time, that's why. All right, they may reject it, my prayer, my lord, but that should be, there should be a finding on that, my lord.
No, your submission is that result would have been same.
My lord,
The result would have been same even if the point would
then, my lord, there is no meaning, my lord, then, my lord, if I file a petition, that it is within time, that will be allowed. That cannot be, my lord. So it is a, that's why
My
I'm submitting.
query is under Article 227, while exercising the power of superintendence,
My lord,
mere failure on the part of the trial court to decide one of your submission, does it warrants interference merely on that ground? If the result would have been the same,
no, definitely it will be decided, my lord, your lordship kindly see that what to count, my lord. Because they are trying to improve the case, my lord, by incorporating some that, my lord, that document, my lord. Your lordship kindly see what my objection, my lord. My objection is specific objection is that, my lord. There is no finding on that, man. By giving reasoning and finding.
No,
on-
but if you can file your written statement against the amendment.
He is always open, and not on that. Because if it is allowed, then I am entitled to get my WS, my lord. I file my WS.
Yes.
But my lord, when I raise this question, your lordship kindly see that in my order, at least my lord, my contention, it is reflected but no finding. It is mentioned, my submission were mentioned. Only my submission were mentioned. No finding on given on that.
Okay.
Your lordship kindly see in para 5, I have clearly
Okay,
stated,
your main contention is that your submission was not considered while deciding the
my lord,
amendment petition.
my lord.
Okay.
My lord, they try to, my lord, this amendment try to improve the case, my lord, and to just to fill up the lacuna. That is also, my lord, that will be, there is no finding at all, my lord.
You were relying on some judgment.
Yes, that judgment, my lord.
What it says that
My lord,
if it changes the nature of,
unless,
it changes the nature of,
yes, unless, that is para 70. That is percent.
yes.
May I please, your lordship? My lord, whatever the submission made by my learned senior counsel is based on the record. Now, my lord, a case of a specific performance of contract and declaration will never get changed by simply inserting that at the time of getting the decree, I may be put in possession of the property by ousting the person who has agreed to sell it to me. Nature and character will remain the same, my lord. My first contention of my learned friend is that the amendment will change the nature and character of the shoot. Second is that it should have been done prior to the start of the trial. In my respectful submission, your lordship, before your lordship, an amendment which is going to be allowed should not be allowed if it is going to change the nature and character of the shoot.
Yes.
Should not be allowed, according to him, as per 2022 Supreme Court he has placed, that an amendment should not be allowed provided it is changing the nature and character of the shoot. My lord, the amendment my learned friend has already sought for, read, whether that amendment which is going to be inserted in the plaint will change the nature and character of the shoot, whether the shoot of declaration and a specific performance of contract in any way get changed. No, and more so, my lord, when my learned friend has already made a counterclaim to that, stating inter alia that 48 lakhs rupees is not paid to me, and 2 lakhs I am not going to receive, and I will not execute the sale deed.
And also for cancellation of that agreement.
Cancellation of my lord?
Agreement.
Yes, cancellation of agreement. It will never change the nature and character of the shoot. Because his counterclaim is a claim which is likely to be treated as a plaint, my lord.
Yes, no, okay. His submission is that the main suit was for specific
Declaration.
performance of contract.
No, my lord, declaration.
What declaration?
Declaration that the defendant has received rupees 48 lakhs from the plaintiff.
Okay.
That declaration, my lord, because if your lordship pleases to see this, the prayer number 1, my lord. It is page number 7 of the plaint, my lord. Page number 7 of the plaint.
Yes.
7 of the plaint. Declaring that the plaintiff is entitled to a specific performance of contract of agreement for sale dated 18/2/2021, executed by the husband of the father of the defendants, that is late Hitesh Saikia. My lord, the the frenziness has started only after the demise of Hitesh Saikia, who took my lord money, and they have also taken this money, my lord. Directing the defendants to execute a registered deed of sale of the scheduled land in favor of the plaintiff within a specific time after accepting the balance consideration amount of rupees 2 lakhs. In the event of failure of the defendants to execute the sale deed in favor of the plaintiff, the sale deed may be executed and registered by the honorable court as per the provisions of Order 21, Rule 34 of the CPC, then cost of the shoot and any other relief. What was not here, my lord, that in case of granting the decree, the
After
pla-
execution of the sale deed.
yes,
you
after execution, I should be put in position. That will never change the nature and character of the shoot, my lord. And moreover, my lord, the trial has not yet started. They are yet to file the written statement against the amended petition together with that of the counterclaim, my lord.
And his plea that the impugn order does not, without considering his, without making any whisper on his,
My lord, that can be considered at any stage, because trial is yet to start. And that plea he can take in the counterclaim, my lord, which itself is a plaint. And so far the amendment is concerned, my lord, in my respectful submission before your lordship, as per this Life Insurance Corporation.
no,
versus
before that,
case.
my
Yes.
one query, before that.
Yes,
One of his submission is that this court should invoke superintending power because the trial court, while passing the impugn order, did not consider his submission. Though it reflected his submission, no finding was given as to whether it would change the nature.
my lord,
There ought to have been some finding by the trial court on his submission.
his submission, my lord, is that the nature and character of the shoot will get changed.
But the trial court remained silent on
No,
that.
the trial court has already come to the finding, my lord, while adjudicating the matter of Order 7 Rule, Order 6 Rule 17, my lord, that it will not change the nature and
Where,
character
where?
of the shoot. It is very much there.
Where? If it is there,
My learned friend has already read that part, my lord.
Only one paragraph.
Ah, yes. Kuntu paragraph.
104.
Huh?
Page 104.
1042. Excellent. Yes.
The court may at any stage. of the process.
My lord, I would like to read that before your lordship. Seen the petition, under the aforesaid circumstances, the opposite party, 103, page number 103, my lord.
yes.
Seen the petition, heard both sides. On perusal of record, it is seen that the instant connected suit was filed on 27/4/2023, whereby the plaintiff, on the basis of agreement for sale dated 20/12/2021, sought a specific performance of the contract by the defendants. Further perusal of the record, especially the plaint, reflects that the plaintiff pleaded about payment of earnest money amounting to rupees 48 lakhs in advance amount of total sale consideration price of rupees 50 lakhs one, along with consequent taking possession of the shoot land and fencing the same, installation of crusher machine, construction of Assam type room for the office, etc. Further perusal of the record shows that the defendants filed their statement and counterclaim and pleaded regarding their position over the shoot land. The plaintiff in the instant amendment petition asserted about her disposition by the defendants on 24/6/2023 and 24/6/2023. My lord, here I would like to pinpoint only one thing, that my suit was filed on 27/4 in the month of April, 27/4/2023.
So after filing of the suit, you were disposed.
I was dispossessed. So that also becomes incumbent on my part to seek possession of the property, my lord. Then, my lord, the plaintiff in the instant amendment petition asserted about her disposition by the defendant on 24/6/2023 and also about discovery of a few documents regarding which she has stated to have no previous notice, as those were in possession of her son Ajay Kumar Chaudhary and Govind Kumar Chaudhary, and also asserted that Govind Kumar Chaudhary has to be impleaded in the suit for just and proper adjudication. Order 6 Rule 17 of the CPC lays down provision of amendment of pleading, and it states that the court may at any stage of the proceeding allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of diligence, the party could not have raised the matter before the commencement of the trial. It is clearly seen that the provisions of law allow the parties to amend their pleadings at any stage of the proceeding before commencement of the trial. The case record reflects that the instant petition is filed when the suit is posted for filing written statement against the counterclaim of the defendants, and as such, the trial court in the connected suit has not commenced yet. Considering that the facts asserted to be inserted in the pleading by the plaintiff is a subsequent development after filing of the suit, and the trial has not commenced yet. As such, the prayer for amendment is allowed. This case is disposed of accordingly. Disposed, yes. So that finding, whether the finding at this stage that the nature and character of the suit will not get changed, whether it is necessary at this stage, my lord, when the entire proceeding is yet to be, put under the trial. Entire proceeding is yet to be put under the trial.
No. His submission is that amendment could not have been allowed if it changed the nature of the suit.
Correct.
Therefore, this
No,
submission ought to have been
recorded.
and discussed why he is allowing the amendment.
My lord, for that purpose, the learned trial court has already quoted the provision of law that the trial has not yet started. And that proviso clause, which is made under order 6. Rule
So,
17,
so
my
is
lord,
it your submission that it implies that
the trial has not yet started. And
no, that is not his submission. His submission is that he made a specific plea
yes,
that if it changes nature of the suit, if any proposed amendment changes the nature of the suit, such amendment should not be allowed. And he shows law in support of his submission.
yes,
His submission is that the trial court ought to have considered and given some finding on his submission, either yes or no. But without considering his submission and without giving any finding on his submission, it allowed the prayer for amendment of the plaint, which is in which he submits that which
not
warrants invocation of powers under
Yes.
227.
yes. But my lord,
I want answer on that from you.
then should we take it on some other day, my lord, just to answer that?
Ye- Yes,
Yes.
whether 227 powers can be invoked under such circumstances.
That is fine. Because rightly or wrongly, but otherwise 227, my lord, your lordship kindly see if it is within time, my lord, then.
No,
then-
and one more query from my side.
Yes, ma'am.
If the result would have been same, even after considering and reflecting his plea, if the result would have been that the court would have allowed the amendment application, then is it justified to interfere in that order by invoking 227?
My lord,
When?
as your lordship. please.
I am always there, but I want on little accommodation, sometime in very other court, but I never take time, my lord.
Yes.
Only my lord.
No, before I forget your submission.
My lord. I have complete my part.
Heard Mr. P.J. Mohanta, learned senior counsel, assisted by Mr. P. Gogoi, learned counsel for the petitioner. Also heard Mr. A. Sattar, learned counsel for the respondent. During the course of the hearing, a query was posed as to whether the impugn order justifies invoking powers of superintending powers of this court under Article 227, inasmuch as it did not consider the plea / argument made by the learned counsel for the defendant before the trial court, that The proposed amendment would change the nature and character of the suit. And without considering this said submission, it allowed the amendment application. On this, learned counsel for the respondent prays for some time to answer the query and to show authority in support of his submissions. Let this case be listed again on,
My lord, on first, that is Saturday, no doubt, but the court is open, my lord.
okay, on first,
My lord, probably not. You already fixed some.
Then on
program,
third, my lord.
Because it was already program was.
third,
My lord.
Three.
on 3rd of November,
Yes.
as part heard matter.
My lord.
Pleasure.
Item number. Yes,
For the respondent is just coming.
we'll take it up after some time. Let him come. Next item.
Railway matters, I am paying for the.
16 also after some time.
17.
Mm. 15 or lawyer kuna sine. Yes, no, item 16. I forgot your name. B. Sharma. We'll take it up after. After, okay, let him come. Let the other side come.
I can take your lordship through the facts of the case. my lord.
Yes. 15.
15 is Siddheshwar Transport, my lord. It's an appeal filed by the private parties, my lord, against the railways. The original application was dismissed by the railway claims tribunal. If lordship comes to page 12, my lord, that is the judgment impugned. First 2-3 paragraphs, my lord, the facts are narrated, my lord. Page 12. Your lordship got that, no?
Yes.
May I read out, my lord?
No, let him come. We'll take other matters. Any other councils? We'll take it 19 first. Yes.
I think I have made it clear, possibly. I'll come back to you.
Yes, Mr. Rathi.
Apologies, man.
What are the facts?
My lord, in respect to case of the Ginger route, my lord,
Just 15 is Siddheshwar.
my lord, in respect to item number 15, if your lordship may kindly grant 1 day accommodation, my lord,
Okay,
today, in respect to 15, my lord.
okay. Heard Mr. D. Rathi, learned counsel for the appellant. Also heard Mr. B. Sharma, learned standing counsel in a railways. Learned counsel for the appellant prays for a short adjournment on the ground of personal difficulty, to which the learned standing counsel NF Railway does not raise any objection. And the same is allowed.
Can a date be fixed, my lord?
Any date, my lord.
Second week of November. Let this matter be listed in the second week of November on a date to be fixed by registry.
Much. My lord, in respect to item number 16,
16.
my lord, in this matter, what has happened is, I have booked the consignment, my lord. And my lord, during the transit of the consignment, it is a case of a non-delivery of the consignment. The consignment was never ever,
Lost.
my lord.
Consignment was lost.
By the police, my lord, Assam police.
Police. It
It's
was
on the
seized
siege
Okay.
till now.
by the forest department itself, my lord, it was seized.
What was the consignment?
My lord, if your lordship will look upon the impugned judgment, Bonsam dry, 34 bags of Bonsam dry, my lord.
What is Bonsam dry? What is this?
This is what we call in Assamese and Hindi dalchini, that is used in cooking. That probably it's that, my lord. Some reference lordship will find in the later portion of the judgment.
Yes.
Probably it's that.
Okay, Bonsam dry. Then
Then, my lord, I booked the consignment, my lord, and the consignment was never delivered. It was seized by the forest department, my lord.
okay.
Now, my lord, my claim was repudiated on the ground of section 93D of the Railway Act, my lord.
What is section 93D, Railways Act?
My lord, it is stating that railway has to take due diligence and care, general responsibility of the railway administration, my lord. What is the general responsibility?
No, no. Why the tribunal rejected your claim?
My lord, as per section 93D,
There is an exception, my lord, under which the responsibility cannot be laden on the railways, my lord. In case of arrest, restraint,
Act
or
of God.
seizure under legal process.
Yes,
Now,
my lord.
these goods were seized under legal process, so the responsibility.
That's why my claim was repudiated.
cannot be laid on the railways.
93D,
93D, my lord. If your lordship,
restraint Caesar. Okay.
however, my lord, if your lordship may look upon the exception, it is a non-obstant clause in 93, last paragraph, my lord. Section 93, last paragraph. Provided that, I'll just read from the starting, my lord, if your lordship permit.
Yes, yes.
General responsibility of a railway administration as a carrier of goods. Save as otherwise provided in this act, a railway administration shall be responsible for the loss, destruction, damage, deterioration in transit, or non-delivery of any consignment arising from any cause except the following, namely so and so, my lord, act of God, act of war. The tribunal has denied on this on the ground of subsection D, which is arrest, restraint, seizure under legal process. However, my lord, if your lordship may look upon the last paragraph of this section, it is stating, provided that even where such loss, destruction, damage, deterioration, or non-delivery is proved to have arisen from any one or more of the aforesaid causes, my lord, emphasis applied, any one or more than aforesaid causes, the railway administration shall not be relieved of its responsibility for the loss, destruction, damage, deterioration, or non-delivery unless the railway administration further proves that it has used, emphasis again applied, my lord, it has used reasonable foresight and care in the carriage of the goods, my lord. It is the duty upon the railway authorities to use the foresight, my lord, reasonable foresight, care, and at the time of handling and carriage of the consignment, my lord. My lord, I'm stating this subsection, the exceptional part of the section 93 because, my lord, if your lordship may look upon the transit pass, my lord.
in the lower court record, my lord, the transit pass is there.
Yeah, LCR. Where? At page?
My lord, it is at page number 2, my lord.
Who is the order sheet? The records of the tribunal is paginated on the right hand top side.
My lord, if I'll just.
It's the
Transit pass.
Forest Department,
okay.
Nagaland document, transit pass, page 2.
Transit pass.
11, page number 10 and 11.
My lord, page number 10.
Yes, what you want to say? Yes,
My lord, in this case, the consignment was seized by the forest department.
Yeah.
And my lord, if your lordship may look upon page number 10. My lord, forest department transit pass, if your lordship is there.
page number 10 is a bill,
10 and 11, my lord.
11, yes.
Transit pass, forest department, Nagaland transit pass, it is mentioned, my lord. Then, my lord, the transit pass number has been mentioned as 2937 in the top right corner, my lord. If your lordship is there, 2937, top right corner. Transit pass number.
Top right,
Yes, my lord, top right corner.
TPN 2937.
TPN 2937, my lord. Above 01, it is mentioned in bold. In the transit pass. my lord.
2937 is the bottom left corner, not top right. TPN 2937.
My lord, that is the, I'm matching these two documents, my lord, in this, in the first document, my lord. And my lord, I'm talking about this document. It is in regard to transit pass. My lord. The other one is the.
That is at page number 9.
My lord.
Page number 9.
My lord, this 29, this is the transit pass, my lord, issued by the forest department, my lord. So, my lord, whenever a consignment is booked, it is the transit pass. The purpose of the transit pass is whenever a clearance from the forest department is required, the transit pass has to be given by the railway authority, my lord. And subsequently, if your lordship may also look upon at page.
Railway authority. Forest Department. Railway Council. This is the
My lords, if your lordship may look upon the PW bill, that is the railway receipt. At page number 1011, my lord, in the below top left corner, bottom left corner, if your lordship has observed, transit pass number has been mentioned, my lord, in the bill itself. 2937, my lord.
Yes. So what do you want to say?
My lord, my humble submission is if your lordship may look upon the judgment of the learned tribunal, the railway authorities has not complied and has not taken reasonable as per section 93 lordship, it was mandatory upon the railway administration shall take reasonable foresight, my lord. Care and foresight, my lord.
What, in what manner?
Whenever a consignment has been traveled, the railway authority, as per section 93, which is general responsibility of the railway authority, it is mandatory that a reasonable care and the foresight should be taken.
Yes, foresight, reasonable care and foresight. What ought to have been done? What ought to have been done
What-
and what has not been done by the railways?
Exactly, my lord. My lord, the transit pass is there in the PW bill and the railway receipt issued by the railway authority. The the transit pass number is also mentioned. The transit pass has also been given to the railway authority. Thus, whenever a consignment, since the consignment was carrying from the forest, my lord, the forest department seized my commodity. It was upon the railway authority to show that there is a transit pass been given. They have nowhere mentioned, railway authority has not shown this to the forest department, or else the consignment would have been given a clear permission to go. And apart from that, my lord, we have repeatedly, since there was non-delivery of the consignment, we have repeatedly sent notices and letters that asking where is my consignment, what is the status of my consignment. However, railway has not even given a single reply to this, my lord. Not a single reply. And at the time of filing of at the time I preferred a claim before the Railway Claims Tribunal. In the written submission, my lord, when the railway, after 8 years, my lord, when the railway is preferring the written submission after apology, I'm not sure, my lord, 8 years, but after many years, I'll just check, my lord, more than 5 years, railway is saying that it has been seized by the forest department, my lord. And now, if your lordship may look upon section 106, my lord, the notice which I have repeated letters and notices which I have issued under section 106, my lord.
To whom? Railway?
To railway authority, seeking what
No,
inquiry and
No,
investigation.
my query is, what railway ought to have done? Showed the transit pass to the forest department at the
Yes.
time of seizure.
Yes, my lord. That should have been done, my lord.
And they failed to show it.
Exactly.
Okay.
And in PW bill, in the railway receipt also, my lord, the PW bill number is my transit pass number is mentioned. Every detail has been mentioned in the railway receipt.
Why this seizure was made?
My lord, that is also very unknown. If your lordship may look upon my notices and letter, my lord, I have repeatedly sought where is my consignment. I have repeatedly sought what is the status. It has not been delivered. It has been months. It has not been delivered. Railway has not given a single reply. And if your lordship may look upon section 106, my lord, why I am saying, my lord, the railway should have conducted an inquiry and investigation and should have given me a reply, my lord, because 106 is stating that it is mandatory that railway should conduct an investigation and inquiry and revert me back, my lord. Railway has not conducted any of those things, my lord, under 106, my lord.
What is 106?
My lord, 106 is speaking about that a claim notice has to be preferred before lodging a original application, filing original application before the Railway Claims Tribunal, my lord. And language of the 106, my lord, if I'll read, my lord.
Yes.
A person shall not be entitled to claim compensation against a railway administration for the loss, destruction, damage, deterioration, or non-delivery of the goods carried by the railway, unless a notice thereof is served by him or on his behalf. Further, my lord, to the railway administration to which the goods are entrusted for carriage, to the railway administration on whose railway the destination station lies, or the loss, destruction, damage, or deterioration occurs within a period of 6 months from the date of entrustment of the goods. Further, my lord, any information or any information demanded or inquiry, emphasis applied, my lord, on subsection 2. Any information demanded or inquiry made in writing form or any complaint made in writing to any of the railway administration mentioned in subsection 1 or on behalf of the person within the said period of 6 months regarding the non-delivery or delayed delivery of the goods with particular sufficient to identify the goods shall, for the purpose of this section, be deemed to be a notice for claim for compensation. A person shall not be entitled to a refund of an overcharge in respect of goods carried by the railway unless a notice thereof has been served by him or on his behalf to the railway administration. Overcharge has been paid within 6 months, my lord, from the date such payment or the date of the delivery
of the destination, whichever is later. My lord, as per subsection 2, which is stating that an inquiry and investigation has to be done, my lord. And Honorable Apex Court, in two of the judgment, my lord, Honorable Apex Court have held that whenever a notice under 106 has been made, railway has to conduct an inquiry and investigation and should revert back to me, my lord, regarding my claim, my lord. After 5 years at the time of filing of written submission, my lord, after break, my lord, I will place the accurate time, my lord. The railway are stating that you have, your goods have been seized by the forest department.
Okay, we will continue at 2. At 2 we'll continue.
Much.
You-
I take your injunctions, lordship. I pray for a accommodation, item number 20. If a person is
Item number
20,
20?
of today's causes.
Okay.
Daily causes. Lordship. If a person confident, I'll be unable to do the method today. Lordship.
Who is for the other side?
Respondent number 124, Lordship.
Okay, heard Mr. A. Acharya,
Yes.
learned counsel for the, sorry, appellant. Also heard Miss B. Hajurika, learned counsel, appearing for respondent number 124. Learned counsel for the, any other counsel is present?
No, Lordship.
Learned counsel for the appellant prays for an adjournment on the ground of personal difficulty, to which learned counsel for the respondent does not make any opposition, hence the prayer is allowed. When do you want it?
Second week of the November. Lordship.
Third week, second week we have matters.
Lordship.
Let this matter be listed in the third week of November on a date to be fixed by registry.
Highly agree.
May I please, your lordship?
Yes.
Lordship, I beg to adjourn item number 21 with consent of other party.
Item number 21.
My senior is hospitalized. Your Honor, due
What
to
is your
some
name?
health issues. Yes, Sheikh.
Heard Miss S. Sheikh, learned counsel for the appellant, who prays for an adjournment on the ground that her senior, who is the conducting counsel for the appellant, is indisposed. Also heard Miss B. Hajurika, learned counsel for respondent number 1 and 2, who does not oppose the prayer. The prayer is accordingly allowed. No date, it will be listed.
Please, your lord.
Yes, Mr. Rathi.
My lord, I have flagged the relevant LCR records.
Yes, good. Now, what is your submission?
My lord, I'll just, lordship may kindly look upon, this, letter dated 2 July 2030 at page number 13 of the LCR. record. Second July 2030.
Page number?
13, my lord.
Yes. Yes.
If your lordship may look upon the para 3 of the letter, my lord. My lord, in this letter, I have sought that that consignment has not been delivered to me and sought for the status of the delivery of the consignment, my lord.
Yes.
Apart from that, my lord, again, a letter was issued, amendment claim letter was issued, my lord, on 5/9/2013, my lord. at page number 17, my lord.
Yes.
However, again, no reply was given to this letter also, my lord. None of the replies was given to the any of the letter, my lord. And lastly, my lord, at page number 12, another letter was issued by me on 23rd April 2013, my lord. At page number 12.
Yes.
Again, I have sought, my lord, the status. I have issued notices and letters seeking details of the delivery of my consignment. What is the status of my consignment? I have intimated the railway authority that I have not received my consignment. Kindly provide me the details of the consignment. It has not been delivered to me yet. However, my lord, not a single reply was given by the railway authorities to any of these notices, claim notices, letters after repeated approach. Now, my lord, if your lordship may kindly come to the written statement at page number 33.
Yes.
At paragraph 7, my lord. Herein, it is stated, my lord, that the deponent begs to state that the competent authority, if your lordship is there, my lord,
Yes.
that the competent authority of the Forest Range Officer, Guwahati Range, has seized the consignment in question from platform number 1 in front of GRP station, White Caesar memo dated 21st April 2013, my lord. Since then, the said consignment were in the custody of the Forest Department. My lord, my humble submission is, my lord, I have issued repeated letters, notices seeking the details of my consignment. Not a single reply was given. Straight away, my lord, at the time of filing of the written submission before the learned RCT, my lord, in the year 2013, my lord, which is almost after 4 years of the date of the booking, my lord. After 4 years, I have been informed that my consignment has been seized by the Forest Department, my lord. And what is the inquiry and investigation conducted by the Railway Authority? When I issued, my lord, 3-4 notices later, nothing was done, my lord. Not a single inquiry, investigation, or resolution was made by the Railway Authority, my lord, which is not serving the purpose of Section 106 of the Railway Act, my lord. If your lordship may, my lord, may look upon the judgment passed by the Honorable Apex Court, my lord. Honorable Apex Court is stating that the purpose of 106 is to Railway Authority to conduct an investigation and inquiry.
Which para?
23, my lord.
Please read.
The high courts in India have taken the view that the object of service of notice under this provision is essentially to enable the railway administration to make an inquiry and investigation as to whether the loss, destruction, deterioration was due to the consignor's latches or to the willful neglect of the railway administration and its servants, and further to prevent the stale and possible dishonest claim being made when the allegation made by the consignor. In this connection, we may refer to so and so forth, my lord. Has also been held by several high court that a notice under Section 77 should be liberally construed. My lord, it pertains to the old act, my lord. In 106, Section 77 was of the old act, my lord.
Thank you. 1959.
1959 judgment, my lord. At that point of time, my lord, the old act, there was Railways Act, Old Act, Section 106 was Section 77, my lord.
Different provisions, my lord.
Yes, my lord. There was Railway Act before this, my lord. The Section 77 and 106 are both same, my lord.
No, no,
Just like IPC and BNS, my lord.
no, not at all.
My lord, subsequently, my lord, Honorable Supreme Court has given a similar observation, my lord, in a recent reportable Supreme Court judgment passed by Honorable Justice Sandeep Mehta and Justice Pardiwala, my lord, 2024 judgment, my lord. At para 40, if your lordship is there, my lord. The Gujarat High Court judgment has been relied upon by the Honorable Apex Court. It's a reportable judgment, my lord. Herein it is stated, my lord, if your lordship is there at para 40.
Yes.
The High Court of Gujarat in its decision in so and so forth, so and so has observed that the object behind the time limit prescribed under section 78B 1980 Act is to prevent stale and dishonest claim from being made, which is otherwise allowed, would make it difficult to inquire into their merits due to lapse of time. Subsequently, my lord, the relevant portion has also been extracted, which is stated. The object of service of notice under this provision clearly is to enable the railway administration to make an inquiry and investigation as to whether the loss, destruction, deterioration was due to the consignor latches or to the willful neglect of the railway administration and its servant to prevent the stale claims, my lord. Thus, my lord, my submission are in two aspects, my lord. One is under 106, my lord. I have issued the railway should have conducted investigation inquiry to my claim 5 years after they are stating that your goods have been seized by the forest department. Secondly, my lord, under section 97, non-obstant laws under 97, it is mandatory upon the railway authority to take due care and reasonable foresight at the time of carriage of the consignment, my lord. My lord, transit pass was there, my lord. In the railway receipt and the PW bill, the transit pass number was also mentioned, my lord. Permission was granted by the forest department, my lord. However, due to negligence and the careless and the cavalier approach of the railway authority have failed to mention that there is a transit pass permission of the railway authority, my consignment was seized. And I was appraised this after 5 years, my lord. Not a single reply to my notice, my lord. I've shown your lordship, my lord, the transit pass and the PW bill. The transit pass is mentioned, given by the forest department, my lord. Permission was issued by the forest department, my lord. Transit pass number is also mentioned in the railway receipt and the PW bill, my lord.
Okay.
That is my humble submission, my lord.
Now, is it your submission, had the railway had shown the transit pass to the forest department,
Yes, madam.
your consignment would not have been seized?
Yes, madam. The permission was given by the forest department itself. Transit pass was
Okay,
issued by forest department.
Yes, Mr. Sharma.
Before I. Sorry, ma'am. Before I make my submissions against his submission, I would like to take certain provisions of the Railways Act
Yes.
for your lordships, my lord. First provision would be section 74 and 76. Who is entitled to file a claim application seeking compensation? My lord? It's relating to that only. Whether the person concerned herein who had filed the OA was entitled to file the OA. That
Yes.
aspect he has not dealt with. May I read out section 74?
Yes.
This application was rejected on two grounds. One was that he was not authorized to file this application. Section 74, my lord. Passing of the property in the goods covered by railway receipt. Here the railway receipt would be the PUA bill, parcel way bill. It says the property in the consignment covered by railway receipt shall pass to the consignee or the endorsee, as the case may be, on the delivery of such railway receipt to him, and he shall have all the rights and liabilities of the consignee. Now herein, in this case, the person concerned who has filed the original application, he is neither the consignee, neither the consignor nor the consignee, and he is not even the endorsee, man. I'll show that subsequently. Now, lordship may come to section 76. Surrender of railway receipt. Your lordship got that?
Yes.
The railway administration shall deliver the consignment under a railway receipt on the surrender of such railway receipt, provided that in case the railway receipt is not forthcoming, the consignment may be delivered to the person entitled in the opinion of the railway administration to receive the goods in such manner as may be prescribed. So it's only on surrender of the railway receipt that the goods would be delivered. And who holds the railway receipt? It's either the consignor, the consignee, or if it is endorsed to someone, that person also can hold on to the railway receipt. Now, Lordship may kindly come to section 106 of the Railway Act now, my lord. By referring to this section, he says that the railway is required to conduct an inquiry. Now, there cannot be a more misleading statement than this, my lord. Has your lordship got section 106?
yes.
May I read out, my lord?
Yes.
Notice of claim for compensation and refund of overcharge. A person shall not be entitled to claim compensation against the railway administration for the loss, destruction, damage, deterioration, or non-delivery of goods carried by the railways unless a notice thereof is served by him on this behalf to the railway administration to which the goods are entrusted for carriage, or to the railway administration on whose railway the destination station lies, or the loss, destruction, damage, or deterioration occurs within a period of 6 months from the date of entrustment of the goods. Now, this subsection 2 is relevant. Probably referring to this, my lord, he says that an inquiry is required to be conducted. What does it say? Any information demanded. Who demands, my lord? The consignor, consignee, or the endorsee. Or inquiry made in writing. It's not an inquiry to be conducted by the railway. It's an inquiry which is made by the consignor, consignee, or the endorsee in writing. It has got nothing to do with conduct of an inquiry by the railway, my lord. This is clearly a misleading statement. I'm reading it out again, my lord. Any information demanded or inquiry made in writing or any complaint made in writing to any of the railway administration mentioned in subsection 1 by or on behalf of the person within the said period of 6 months regarding the non-delivery or delayed delivery of the goods with particulars sufficient to identify the goods shall, for the purpose of this section, be deemed to be a notice of claim for compensation.
No.
If such inquiry is made in a written form to the railways, that itself would suffice as a notice, my lord.
Okay. Yeah. Okay, that is right. But
My lord.
but you have not responded to his notice under 106.
Responded in the written statement. There is
But
no,
that is after 4 years.
in 2013 itself, notices of 2013, 106. 106 notices of 2013. In fact, his
And-
claim was, I've got a document with me. Probably it's not there in the records, my lord. It was issued to the claimant hearing. I can just place it before your lordship for perusal.
No, you make your submission first.
Okay, I'll place it lastly, my lord. In the written statement, we have clearly stated that that the document, the
No.
consignment was seized by the,
When the consignment was supposed to be delivered,
if it was not seized by the authorities, then my lord, within 4 or 5 days from the date of fever, it would have reached its destination, my lord.
what was the date? Approx.
Never delivered.
Year or date.
EUA bill,
The consignment was booked on 5 September 2013, 5/9/2013.
5/9/2014.
Eight apologies, 8/4/2013.
8/4/2013.
Date of booking was 8/4/2013.
Then why have you stated that it is, you were informed for the first time in WS after 4 years? No, but how it will be after 4 years?
The return statement was 17 and 18, my lord. The date, the seal and stamp is also there at page number 22, my lord.
Take your seat.
Now, I placed the document of 2013 before your lordship later. on.
What is that document?
That he was informed. Informed by the, I'll place it, but now let me answer to the
Okay, okay.
to the arguments made by the other side. my lord. If lordship takes up the judgment. The third page of the judgment, my lord, first, second, third, where the issues have been decided. Issues number 1 and 2. For this paragraph, I had placed before your lordship section 74 and 76.
Please.
I'm reading it down. Perusal of the case record shows that
Which para you are reading?
6.
Para 6, yes.
Perusal of case record shows that alleged legal notice under section 106 of the Railways Act 1989 was duly served on the respondents by Sri Gajendra Rawat. The applicant herein, however, the same does not contain the diary number. Further, the bill filed along with the claim application reflects the name of the seller as Jamir Conveser, that is the consignor, my lord. The name of the purchaser as Jitendra Srivastav, who is the consignee. And the date of purchase was 7/4/2013. The transit pass issued by the Assistant Conservator of Forest Nagaland reflects the name and residence of pass holder, which is not legible. All these persons should have been joined as claimants in the present case of such nature, where the goods have been seized or at least as pro forma respondents. In the absence of the same, I feel the claim is not properly verified, signed and filed by him, and he does not hold legal title. The consignor was Jamir Conveser. The purchaser, that is the consignee, is Jitendra Srivastav, and there was no endorsee at all in this case. Mr. Gajendra Rawat is not an endorsee, neither the consignee. So how can he file the claim application? Now, coming to the next paragraph, which is most relevant, my lord, why the case was rejected on merits. As regards, married or married?
Yes, yes.
As regards non-delivery of 34 bags of bonsam weighing 1990 kg by the respondent railways to the applicant, it is seen from the memo number so-and-so dated so-and-so addressed to the DCM Guwahati Railway Station, NF Railway by the Forest Range Officer, Guwahati Range, Government of Assam, marked as Exhibit R1, that the said consignment was seized by the officials of the Forest Department on 9/4/2013 from the platform number 1 in front of GRP station and kept under the custody for verification. The said memo reads as under. With reference to the subject cited above, I would like to inform you that on so-and-so 34 numbers of miscellaneous bark, railway number so-and-so, lordship will kindly note this number, my lord, railway number. This is very relevant. I'm requesting your lordship to take a note of this number. That will reveal the entire misleading aspect, my lord. How even your lordship is they're trying to mislead your lordship. Railway number so-and-so, minor forest produce, kept on our custody for verification, which were detected at platform number 1 in front of GRP station. This is for favor of your kind information and necessary action. As per section 93(b) of the Railways Act 1989, Railway Administration shall be responsible for the loss, destruction, damage, or deterioration in transit or non-delivery of any consignment arising from any cause except arrest, restraint, or seizure under legal process. Since it is an admitted fact that the consignment was seized under legal process by the Forest Range Officer of the Forest Department of the Government of Assam, and the same is still under their custody, the claimant should have taken up this case of such serious nature with the concerned authorities. The respondent railways cannot be held liable to compensate the loss sustained by the applicant due to seizure of the goods under legal process in view of section 93(d) of the Railways Act 1989. As such, it is held that the applicant is not entitled for any compensation for non-delivery of the goods. The issue number 3 is accordingly decided against the railway. Now, referring to the proviso of section 93 of the Railways Act. If Lordship kindly takes up section 93 of the Railways Act, he is trying to project a case that the railway authorities had not taken proper care of the goods while in transit, my lord. Has your lordship got that
Yes,
section? I'm reading it out again from the very beginning, my lord.
you read the proviso only.
Proviso, provided that even where such loss, destruction, damage, deterioration, or non-delivery is proved to have arisen from any one or more of the aforesaid causes, the railway administration shall not be relieved of its responsibility for the loss, destruction, damage, deterioration, or non-delivery unless the railway administration further proves that it has used reasonable foresight and care in the carriage of the goods. My lord, in my humble submission, these proviso would not be applicable in case of subsection D of section 93 because it has got nothing to do with carriage. Had the railway authorities been careless in transit in carrying the goods, then it would not have reached Guwahati from Nagaland in a safe and sound condition, my lord. It's regarding foresight and care in the carriage of goods. Because the railway authorities had exercised foresight and care in carriage of the goods, that is why it has reached Guwahati from Dimapur in a sound and safe condition. Now, in Guwahati, it was seized under a legal process. Now, answering to the other submission of my learned colleague, my lord, he says that had the railway authorities shown the Purcellway bill to the forest department, wherein there was a mention of the transit pass, then the authorities would not have seized the goods. My lord, this is clearly a misleading statement. The railway authorities did show that the forest authorities. In spite of that, it was seized.
Where is that statement?
Yes, my lord. Lordship may kindly come to page 28 of the LCR. Page 28. The custody memo, my lord. Custody memo.
Caesar,
28, no?
Caesar memo is there at page number 2025 of the LCR.
Pagination is not that seriatim. Half pages are here now.
Just a minute.
Yes, page 28. Custody of minor.
Now, Lordship may kindly take note of that document, my lord. Government of Assam to the DCM, Divisional Commercial Manager, Guwahati Railway Station, NF Railway, Guwahati. My lord, custody of minor forest produced. With reference to the subject cited above, I would like to inform you that on 9/4/2013, 34 bags of missed bark railway number. This is relevant. That's why my lord requested your lordship to take a note of that, my lord. Railway number 8/4 RDMV/235260 P34 CNV5 Guwahati to BJY, my lord, kept on our custody. Now lordship may turn to page 11 probably. That is the Purcellway bill, my lord. Has your lordship got that? PUA bill, the Purcellway bill.
Page.
Lordship will compare the number, my lord. On top, my lord, handwritten DMV 235260. Lordship got the. On top, my lord, handwritten NF DMV 235260 P34 CNP. Lordship got that? So the forest officers were shown the Purcellway bill, that is the railway receipt. And down below, the transit pass number was indicated in the PUA bill. Transit pass number 2937. Dated 23/1/13, that your lordship will find at page 11.
Yes.
So this is clearly a misleading statement, my lord. intentionally made to misguide this honorable court so that they can get the compensation, my lord. And on this ground alone, my lord, this application is liable to be dismissed with cost. What more the railway could have done, my lord? It was not under their control, my lord. If the forest department wants to seize,
Why the forest department sees the matter?
it-
For
for-
verification
for-
only. Then when
maybe he
you,
would have gone there and
but whether he was informed that your matter,
itself,
where,
the document, we are
whether you have mentioned in your written statement that you have informed.
in the statement, but
Not denied.
after filing of the OA, it was not required, my lord. He was required. It's not required of
No,
us to.
you were carrying the goods of a consignor.
Yes.
Goods were seized by somebody
Somebody.
unauthorized day, assuming unauthorized day. Is it not your duty to inform the
Well,
consignor or consignor?
Sani was informed. This is the document, my lord.
It's not in LCA records, my lord. Never produced before the trial, tribunal, my lord. It's something new, my lord.
It's still in the custody of the GRP. After 2017, what he did, my lord? The requirement under the law is to show that the railway is responsible for its negligence. That they have failed to show, my lord. So no case lies. Time and again, they're trying to mislead this honorable court in the court below. In fact, it was rejected once before the destination station for non-pursuance. This is how they behave, filing claims before various stations.
Okay, you have not stated in your written statement.
No, I admit that, but it's not required under any law to give him a reply, my lord. If you can show any document, any provisions of law that we are required to give him a reply
12
on the
note 5.
notice, let him show, my lord, there is any provision, my lord. Once he
So-
had filed a claim application, once he had initiated the process by issuing the notice under 106, was filing the claim application. Our written statement would do the same, my lord, defender. Maybe,
But written statement was filed after.
maybe they never objected to it, my lord. Now they are taking this ground. Let them show one document that one provision that we are required to give them a reply. And it's not that we have not. Lordship has seen that document, we have given the reply, but it was not brought on record. It's not a case that we have not.
No, how will we test the veracity of this letter?
But these are official records, my lord. We have not brought it on record, but it's not the case. That's what I'm trying to impress upon your lordship. And let them show one
I have not
provision.
even seen this document.
Let them,
It's
let
the
them,
first time
let
after,
them show one provision in the Railway Act that after issuing the notice, we are required to give them a reply.
after 12 years, I'm coming to know about this document, my lord, new document.
They know
after
they
12
don't
years.
have a
No,
case.
don't interrupt in between. This is not this way. Let him complete his submission. If you have anything to say, you may reply.
That is, I'm trying to impress upon your lordship. There is no provision that after initiation of the process, that we are required to give a reply. Once the process is initiated for approaching the RCT, everything would be dealt with by the Honorable Railway Claims Tribunal. And in fact, before the tribunal, we had placed our defense. We are never negligent in handling the goods. In fact, the goods were seized under the process of law by the competent authority. Even after 2017, when they came to
Give it back to him. You give a photocopy of this letter. What is the material to indicate that this was actually served on the claimant? This shows, even if it is believed that there exists a letter,
the seal below, that was dispatched, my lord, through post. Seal below, there's a seal. It was dispatched on the next date, date of issues 26/11/2013, dispatched on 27 November. By post.
But
Yes.
there is nothing to indicate.
Dispatch seal is there
Where have you dispatched?
on 27. The dispatch
Date is okay, but
Seal-
where have you dispatched?
to this address, my lord, to Gajendra Road, Lokra Road, near Hanuman Mandir. Even though we are not required to, but we had. My lord. There's not a single provision in the Railway Act that says that after the process has been initiated for filing an original application by issuing the notice under 106, that the railway is required to give a reply to them. Once they had initiated the process,
Okay.
the court will handle the matter, ma'am. And had it been a case that it was due to the fault of the railways, there was non-delivery, I would have accepted the liability. We are no way responsible with the non-delivery. It was seized under a process of law. The forest department would know it. And after knowing that in 2007, he cannot say that after 2017, he did not know that. Why haven't he approached the authorities, the forest department? Obviously, there is something fishy, my lord. Otherwise, he would have approached for delivery. Till that, they have not done.
Yes. What is your
And
locus?
the other thing- locus, yes.
You were not neither the consignor nor the consignee,
My lord. My
nor
lord, if your lordship will
The-
look upon the PW bill, I am the endorsee, my lord.
where is the
Yes, my lord.
endorsement?
At PW bill, my name is written in the area of consignee. At page number 11, my lord,
Yes.
PW bill is there.
Let him show, my lord. This is another misleading statement.
My,
Page number 11.
yes, ma'am. The PW bill is there, my lord. If your lordship is there,
Yes.
my lord, if your lordship may turn the PW bill, which is the railway receipt. So, my lord, if your lordship may allow to brief your lordship in regard to the procedure which is being followed, my lord. Railway receipt consists of two parts, my lord. The first is the front side, my lord, the details of the consignor and the consignee and everything has been mentioned, my lord. And in the back side, my lord, whenever a consignment has been endorsed to someone else by the consignor or the consignee, my lord, the name of the endorsee is being mentioned, my lord. If your lordship may look in the back, it is written in the middle, my lord, right in the middle. Please delivered goods to Sri Gajendra Raut, my lord.
By the consignee.
Yes, my lord. Endorsement has been there, my lord. I am an endorsee in this case, my lord. Secondly, my lord, what my learned friend has, senior friend has just stated, my lord, transit pass was not legible, my lord. It is a duty upon the railway authority to produce the transit pass, since it is in the custody of the railway authority,
No,
not
no,
in
no,
me, my lord.
it's not.
Not with me,
It's-
my lord. Transit
never-
pass has been submitted to the railway authority, my lord. And transit pass is very much illegible. Transit pass number has been mentioned, my lord. In the PW bill, the transit pass number is mentioned, and in the behind of the PW bill, which is the railway receipt, my lord, the name of the endorsee Gajendra Raut is also mentioned, my lord. Thus, I am not the consignor. Endorsee is a misleading statement, my lord. I am an endorsee, my lord.
That is what
Sec- sec- sec-
Yes, yes.
Secondly, my lord, there has not been a denial been made by the railway authority in their written statement that the goods that we were informed, we have written in our original application that we were never informed. At the time of the filing in the entire original application, we are stating that the consignment was never delivered. In the time of filing of the written statement, my lord, WS, my lord, I have been informed, there is not a single document produced before the learned tribunal that I have been informed priorly, my lord. At the time of the filing of WS, and my lord, I am not going into the merits of the document which my learned senior friend has just shown your lordship, my lord. But my lord, the said does not indicates that there has been any kind of a service upon me, my lord.
though it should not be even, this document should not be even considered at this appellate stage after 12 years, my lord. 4 years later, they are informing that your goods has been seized by the forest department. 12 years later, a new document has been produced, my lord. My lord, under section 74, if your lordship may look upon, section 74 is clearly stating that the endorsee has the right to claim, my lord. And I am here the endorsee, my lord, prima facie established, my lord. Secondly, my lord, section 93, my lord. Section 93, if your lordship may just look upon the it is a non-obstant clause, my lord. It will override other sections and other provisions, my lord. It is a non-obstant, 93, my lord. Provided that even where such loss, destruction, damage, deterioration, or non-delivery is proved to have arisen from one or more of the aforesaid causes, the railway administration shall not be relieved of its responsibility for the loss, destruction, damage, deterioration. Unless the railway administration, emphasis applied, my lord, unless the railway administration further proves that it has used reasonable foresight, my lord. Onus of proof is upon the railway authority, my lord, that they have treated the consignment carefully, not negligently, and used the reasonable foresight, my lord.
Okay.
And my lord, lastly, my lord, not denial in the written statement would amount to admission of the fact that I was never ever informed, my lord, regarding this, my lord.
That's, I've already made my argument that there is no requirement, not a single
Yes.
provision in the railway,
That you have to reply back.
there's not a single
That you
provision
have to reply back to a notice under 106.
that I have to reply back to notice. Once the process is initiated by issuing the notice, the matter goes to the
Court.
honorable court, the court
Tribunal.
will decide. Now, if lordship comes to the original application before the tribunal, kitna page number?
I'm not.
Okay, I'm not sure about the
I
page
flagged
number.
original application, my lord.
Yes,
Lordship is- The first page,
21.
title of the case, Messrs. Gajendra Rao, applicant versus the Union of India and so and so. Page number 2, between Gajendra Rao, so and so, so and so. Now, if lordship comes to page number 3, facts of the case. It starts with the heading, facts of the case. Has your lordship got that, my lord?
Yes.
We are the consignee and whole legal title. Is it not a misleading statement? Here he says that he is an endorsee, and in the original application, he says he is the consignee. Consignee is Mr. Jitendra Srivastava. On this ground alone, my lord, this application is liable to be dismissed with cause. On oath, my lord, they are making a false statement. On oath, they file an affidavit to this, my lord. And the PUA bill, I have placed it before your lordships, my lord. That Caesar document wherein the railway PUA bill number was indicated, it's shown that in the PUA bill, and down below, the transit pass number was also given there. So it's not that railway had negligently acted with the consignment. They placed the PUA bill as well as the transit pass before the authorities. Even thereafter, it has been seized. Page 11, lordship may once again have a look at it. Page 11 of the LCR. Clearly mentioned in the PUA bill, the transit pass number. The transit pass lordship will find at page 9, probably. TPN number 2937, and in the PUA bill also TPN number 2937. So these were within the knowledge of the seizing authority who made the seizure, my lord. How can they say that it was not, railway had not placed these documents before the authorities? In fact, in the seizure document, this PUA bill number was given, my lord. So it's clear from that, my lord, that document itself, that the PUA bill, that is the railway receipt, as well as the transit pass document was placed before the authority who had made the seizure. So there was no negligence on the part of the railways. That's my submission. It's an
No,
open and shut
it
case.
will not continue forever.
My lord,
Argument will not continue forever.
yes. My lord, just in regard to the consignee part, which my learned senior friend has submitted in our application, we have mentioned that we are the consignee that your lordship has concerned. My lord, endorsee and consignee, consigner is different, my lord. Endorsee and consignee is used in a usual form, my lord. It has been used in a general form, my lord, and we have also, lordship, I have satisfied your lordship that I am here the endorsee, my lord.
I can improve his case, my lord.
And apart from that, my lord, if you just lastly, my lord, if your lordship will look upon the forest Caesar memo, my lord,
Yes.
Caesar memo, my lord, if your lordship is there at page number 28 of the LCR, my lord.
Yes.
I'll just read the paragraph, my lord. With reference to the subject cited above, I would like to inform you that on 9th April 2013, so and so bag of railway, so and so kept on our custody for verification, which were detected at platform number 1 in front of GRP station, my lord. This letter has been issued, my lord, on 21st April 2013. The railway came to know regarding this on 21st April 2013 that my goods have been seized, my lord. However, it has also been not informed to me, my lord. Lordship, I placed before your lordship judgment of the Supreme Court, two Supreme Court judgment, which is stating that 106 notice inquiry investigation has to be given. At least a reply has to be given, my lord. That has also not been given. And lastly, my lord, from the submission, which is my learned friend submission, that the forest department was informed regarding the regarding the transit pass. It cannot be proved from any of this document, my lord, that the forest department was informed regarding the transit pass.
Okay, heard Mr. D. Rathe. Learned counsel for the appellant. Also heard Mr. D. B. Sharma. Learned standing counsel, NF Railway. Hearing concluded, judgment reserved.
One
Reserving.
thing, just, one
Yes.
thing, it's not a submission, just indication, my lord. The judgment which he have relied pertains to the old Railway Act, my lord. It doesn't pertain to the new Railway Act regarding section 106. So these are not relevant at all.
My lord, Indian Oil Corporation judgment is 2024 reportable Supreme Court judgment passed by Justice Sandeep Mehta, my lord, and Justice Pardiwala.
Sections are totally different.
Section is same, my lord, 106, 24 judgment.
Much obliged.
Much obliged.
Separate file of citations. Given item.
I'm sorry, Dr. Earlier I could not attend. I was in another court.
Yes.
This is a common judgment. MST case number 15 and 16 have been disposed of by common judgment and order, where this appeal has been in respect of MST case number 16 of 17.
No. There are two MSc cases.
Two MSc cases, 15 and 16. 2015 of 17 and 16 of 17.
Before which tribunal?
MSc Kamrup.
Kamrup. And both were for injury or death,
One is death, 15 is death, 16 is for injury.
and both were disposed of by a common judgment by
Common
the tribunal.
This appeal is regarding MSc case number 16 of 17.
Okay.
This is injury case.
Yes.
From page 10 onwards, it has started. Brief fact of the case is, Lordship, in this particular case, injured claimant along with his wife and children were traveling in a bus from Dhubri towards Bhayapesardi.
Okay.
At Paikan, the vehicle got an electric high voltage line short circuit because some bicycle were loaded in the above the bus. Bicycles were loaded in the above the roof of the bus, and it came into contact with the high tension line of the electric.
As a result, was electrocuted and some of the passengers sustained serious burn injuries because of the electric short circuit, and wife died. Wife of the present claimant died,
Okay.
and she filed MST case number 15 and MST case number 16 of 17.
Husband filed both the cases.
Both the case. And 15 has been filed by the husband and the children, and 16 has been filed by her, by himself. Salamuddin.
Yes.
In this particular case, Lordship, admittedly, both leg of the claimant has been amputated
Imputed.
below knee.
Yes.
Because of the gangrene occurred after electric short circuit, there is an infection, both the leg was amputated. There is no dispute to that effect. But in
Yes.
this particular case, Lordship will file at page 10.
Yes.
I want to make it short, Lordship, because Lordship dispute regarding the dispute involved. Lordship will find at page 10, para 26.
Yes.
I have gone through the PW and documents available on record, found that during treatment, both leg of the victim was amputated below knee. Therefore, I have no hesitation to accept the disability to the extent of 80% who has lost his both leg.
Yes.
So my first point will be, if amputation is made below knee, employees compensation act containment. Employees compensation act containment. Because Lordship is aware, for assessment of compensation in Motor Vehicle Act, no schedule has been annexed regarding loss of burning capacity. And disability and loss of burning capacity is two different things. Assessment should be made considering loss of burning capacity. Loss of burning capacity is as per Employees Compensation Act, as per schedule.
Yes.
Lordship will find the schedule, list of injuries deemed to be resulted in partial disablement. That is schedule 1. One is permanent total disablement, one is permanent partial disablement. Lordship can see the schedule 1.
Yes.
Lordship got the schedule.
Yes.
Now I will take your Lordship to schedule 20, serial number permanent partial disablement, schedule 20.
Serial number 20.
Serial number 20. List of injuries deemed to be result permanent partial disablement. Lordship got it.
Yes, serial number 20.
Serial number 20, amputation below knee with term exceeding but not exceeding 12.70, 50%.
Okay.
So this is my first point, that loss of burning capacity should be considered 50%. So tribunal has considered 6,500 rupees as income in para 27. I have no dispute to that effect. 6,500 as a measure, considered 6,500 rupees. I have no dispute to that effect. So loss of burning capacity should be 50%, considering the schedule of the Employees Compensation Act. Secondly, Lordship will find that tribunal has considered 14 as a multiplier for assessment of loss of income
Yes,
at para 28.
yes,
Lordship will find claimant also stated in claim petition at the time of accident he was about 40 years. Claimant has not proved age, and it has been held that he was in the 40 years plus age group of 41 to 45, and accordingly applying the multiplier 14 and adding 25% as future prospect, total loss of earning capacity is calculated to be 6,500 plus 25% future prospect into 12 into 14 into 80%. It should be 50%.
okay.
That is my
So instead of 80% loss of earning, disability,
loss of earning capacity.
loss of earning 80%, it should be
50%.
50%. So the quantum will decrease to that extent.
Compensation will be reduced to that effect 50%. It will come to 50%. We can make it calculation also. In addition to this, besides this lordship, in addition to the amount claimant injured also entitled to loss of expectation of life and amenities of life, 2 lakhs each. Lordship got it.
Yes,
Loss of amenities of life and loss of expectation of life, 2 lakhs each. Lordship got it.
yes,
That is 4 lakhs. Supreme Court has categorically held, I will place a judgment. When there is a loss of expectation of life and loss of amenities of life, that is amount to double compensation. I will place a judgment. It should be 1.
no, I'm not getting it.
Loss of expectation of life and loss of amenities of life. Here, 2 lakhs each has been awarded. Total 4 lakhs.
Okay. 2 lakh each for both the claimants,
No. It is for the injury case.
for injury case, okay.
Loss of expectation
So
of life.
against both the head, 2
Both the
lakhs.
head, 2 lakhs each
So against each head, 2 lakh was awarded.
awarded. It should
Your
be 1.
submission is that it cannot be.
Cannot be. As per
There is
Supreme
a
Court
apex court judgment.
as per apex court judgment. It is amount to double compensation.
Which is that.
I will place as a. Lordship, thereafter, why Lordship? Thereafter, para page 11. An amount of rupees 2 lakhs towards pain and suffering.
Yes,
And rupees 25,000 towards transportation, 25,000 towards nutritious diet, and 25,000 awarded to the claimant as a cost of attendance. And amount of 6 lakhs has been awarded to procure artificial limb of both leg. Total amount is 24 lakhs. I humbly submit, Lordship. Tribunal has awarded 6 lakhs for artificial limb. There is no evidence, but I am in favor of the claimant. There should be some amount towards artificial limb. But there is no evidence to that effect. I have set out the record. There is no evidence to that effect that cost of artificial limbs is 6 lakhs of which. There is no evidence to that effect that 6 lakhs is required for artificial limb. Tribunal has awarded on its own 6 lakhs.
is it excessive or?
And in similar cases, I have seen 2,50,000, 3 lakhs is awarded. Because artificial limb is of different type.
No, there
Which
is
should be
no
treated.
evidence from your side also that the quantum awarded against artificial limb is excessive.
There is no evidence that artificial limb has been installed by the claimant. There is no evidence regarding cost of artificial limb. Tribunal of its own,
It has
awarded 6
assessed
lakhs
on its own.
of its own. In the claim petition also I have checked out, there is no prayer that artificial limbs of rupees 6 lakhs will be required to be.
So what is your submission?
My submission. will be,
Against
Lordship,
this head, no,
because my submission will be, Lordship, because I am not against the claimant always, in except the fraud cases. Because tribunal have to give the just compensation. Tribunal have to give the just compensation considering the fact of the each cases.
for that you have to make submission that this amount is unjust or excessive.
My submission will be, there is no evidence for
No, that is okay. There is no evidence. Tribunal on its own assessment made a rough assessment and gave 2 lakhs,
6 lakhs.
6 lakhs. Unless there is a submission from your side that the artificial limb costs so much or this is excessive, how this court will interfere?
My submission.
Say
will-
without evidence, it,
No.
it gave a finding.
Generally, as per legal principle, when there is no evidence to that effect, no doctor was examined regarding to establish the cause of artificial limb. No evidence has been adduced by the claimant that artificial limb is required to be installed, but tribunal has awarded.
There is nothing how that quantum was computed.
It is available on Google also. Artificial limb below knee. What is the available compensation? I have no objection to that effect. I can give a cost of the artificial limb from the search report.
Okay. Anything else?
Because it is the duty of the tribunal in accident cases to give just compensation. I should be fair in making submission. That is why I'm saying some amount should be awarded for artificial limb also, though there is no evidence. So my submission to the Lordship, in this particular case, 2 limb of submission. One is loss of earning capacity should be 50%. Secondly, 2 lakhs each on pain and suffering, and thereafter 2 lakhs again towards pain and suffering is not legally sustainable. I will place the judgment on this point. The full debt report. I have given the page number of the compilation, page 26 of the judgment passed by the Supreme Court in 2020, 9 SCC 805, page
Page.
26. Page 26.
Yes. Yes, para?
That is a full bench judgment. Para 17,
Para 17.
para 34, page 34.
Yes.
Lordship, what?
Yes.
Under the head of pain and suffering, the High Court has awarded a sum of rupees 40,000. Appellant want this sum to be raised to rupees 6 lakhs, relying a judgment of the Mallikarjun versus National Insurance Company in Kojala, where the victim was a young girl of 12 years of having suffered 100% disability. Eman awarded 15 lakhs under the head of pain and suffering and loss of amenities, but this judgment qualified such award with a caveat. The sum was awarded in peculiar facts and circumstances of the case. In Rajkumar versus Ajay Kumar, it has been observed that when compensation is awarded, treating loss of featured earning capacity to be 100% or even anything more than 50%. The need of award of compensation separately under the head of loss of amenities of life, loss of expectation of life may disappear. Lordship, got it? Under the head of loss of amenities or loss of expectation of life may disappear. As a result, only a token normal amount may be awarded under the head, under those head.
So if there is a compensation awarded against to the extent of 50% or more against loss of future earning, there is no requirement of
Loss of
awarding,
amenities of life and loss of
awarding
expectation.
compensation against loss of amenities of life or loss of expectation. What has happened in the instant case?
Here, Lordship, 2 lakhs has been awarded 3 times. Lordship will find. Again, I will take a Lordship to page 10, para 29.
Yes.
Para 29. In addition to the aforesaid amount, claimant injured is also entitled to loss of expectation of life and amenities of life to the tune of rupees 2 lakhs each, rupees 4 lakhs, and amount of rupees 2 lakhs award to the pain and suffering. That means 6 lakhs.
Okay. But this judgment says that if compensation as regards future earning capacity
No, future earning capacity has been already assessed
at 25%,
at 25%.
but the judgment which you are relying, which says, to my understanding, that if the compensation is awarded by
When loss of earning capacity 100% or above
100%.
50%.
above 50%, then the compensation against the head loss of expectation may not be granted.
In this particular case, admittedly tribunal has considered 80%, it should be 50%. So this amount will disappear. Lump sum amount will come. Token amount. And before this lordship, I'm placing another judgment, that is full bench judgment. Before that, page 18. Page 18 of the compilation. I am placing the full bench judgment. That was 2020. Before that, earlier judgment is Parminder Singh, 2019, 7 SCC 217. Compilation page 18.
Yes. Para?
Para 14 and 15. Same thing, para 15, I am reading para 15 also. It may be noted when compensation is awarded by treating the loss of future earning capacity at 100%, even anything more than 50%, need of award of compensation separately under the head of loss of amenities or loss of expectation of life may disappear. As a result, only token of nominal amount may be to be awarded under the head of loss of amenities or loss of expectation of life. Otherwise, there may be duplication of award and compensation, be that as it may.
No, where are you reading?
Para
Page
15, page 24. Page 24.
Page 24, there is no para.
Page 24, para 15.
There is no para 15, Parminder Singh.
Lordship,
5.8 or 5.8.
above 5.9.
Quotation is there.
Quotation is there. 5.9. That is, I am giving the Rajkumar also, I am placing. Rajkumar also I have given. Rajkumar judgment has been quoted.
Okay, in Rajkumar's judgment, this was.
Rajkumar versus Ajay Kumar, I am placing the judgment also. I am placing the earlier the full bench judgment. This is Rajkumar judgment, is a division bench judgment of the Supreme Court. Where it has been held 5.8. Lordship got it 5.8.
Yes.
Then before 5.9, para 15.
Yes.
It may be noted when the compensation is awarded by treating loss of future earning capacity as 100%, even anything more than 50%. Need of award of compensation separately under the head of loss of amenities and loss of expectation of life may disappear. As a result, only a token of nominal amount may have to be awarded under the head of loss of amenities or loss of expectation of life. Otherwise, there may be duplication of the award of compensation.
What nominal amount may be awarded?
Considering the effects of each cases. I'll place the judgment also, how to be assessed compensation. Considering the avocation of the person, considering the status of the person. In case of an engineering student, that case also, in case of engineering student, Supreme Court has awarded very huge amount.
So what is your submission under say para 29 of the impugned judgment?
Lordship, I have given the Rajkumar also.
Rajkumar has already been quoted.
Rajkumar is already in the compilation in the initial stage because that is a division bench judgment and that has been followed by the full bench.
So
Rajkumar
we'll follow the full bench.
Full bench I have given, Lordship.
Agenda Parminder
Lordship.
Singh.
Rajkumar is 2011 1 SCC 343. At a first judgment.
Okay.
Regarding principle also laid down in para 5, 6 and 8, 13, 15, 16. And WC Act have to
Which para says that?
page 5, para 5.
Yes,
Lordship got it.
yes,
May I read?
yes, please.
The provision of the Motor Vehicle Act 1988, in short, make it clear that the award must be just, which means that compensation should be to the extent possible fully and adequately restored the claimants to the position prior to the accident. The object of awarding damage is to make good loss suffered as a result of a wrong done, as far as money can do so. In fair and reasonable and equitable manner, court and tribunal shall have to assess the damage objectively and exclude from the consideration any speculation of fancy, though some conjectures with reference to the nature of disability and its consequence is inevitable. A person not only to be result of such injury means that he is to be compensated for his inability to lead his full life, his inability to enjoy those normal amenities which he would have enjoyed, but for injuries and inability to earn his much as he used to earn or could have been earned. This principle has been followed. Lordship is aware of the Hatangiris case, pest control versus Hatangiris case. The head under which compensation is awarded personal injury cases, pecuniary damage, expenses relating to treatment, hospitalization, medicine, transportation, nursing, food, loss of earning, which injured would be made to be or not injured, comprising of loss of earning, the period of treatment, loss of future earning on account of permanent disability, future medical expenses, non-pecuniary expenses, damage, pain, suffering, trauma as a consequence of the injuries, loss of amenities, loss of expectation of life, shortening of normal longevity period. In routine personal injury cases, compensation will be awarded under the head of 1, 2A, 1, Roman 1, Roman 2A, and 4, damage for pain and suffering. It is only in serious cases injury where there is specific medical evidences corroborated by the evidence of the claimant that compensation will be granted under any of the heads 2B, 3, 5, and Roman 6 relating to loss of future earning on account of permanent disability, future medical expenses, loss of amenities or loss of prospects of marriage or loss of expectation of life. Assessment of pecuniary items under 2A do not pose any much difficulty as they involve reimbursement of actual and are essential ascertained from the evidence. Award under the head of future medical expenses, item that depends on the specific medical evidences regarding need or future treatment, cost thereof. Assessment of non-pecuniary damage, item number 4, 5, 6 involves determination of a lump sum amount with reference to the circumstances of the age, nature of injury, deprivation, disability suffered by the claimant, and effect thereof on the future life of claimant. Decision of this court and high courts contain necessary guidelines for award under the said. If necessary, what usually pose some difficulties in assessment of loss of future earning on account of permanent disability, item number 3 and 4, we concern with that assessment in this matter. Now I am reading assessment of future loss of earning capacity due to permanent disability. Disability refers to any restriction to lack of ability to perform activity in the manner considered normal for a human being. Permanent disability refers to residual incapacity, loss of use some part of the body found existing at the end of the period of treatment or recuperation after achieving the maximum bodily improvement and recovery which is likely to be remain for the remaining life of the injured. Temporary disablement refers to incapacity or loss of use some part of the body on account of his injury, which will cease to exist at the end of period of treatment and recuperation. And permanent disability can be either partial or total. Partial permanent disability refers to a person's inability to perform all duties or bodily function that he could perform before accident. Though he is able to perform some of them, he is still able to engage in some gainful activity. Total permanent disability refers to a person's inability to perform any avocation or employment relating to activities as a result of the accident. The permanent disability that may arise from motor accidents are of much wider range when compared to physical disability, which are enumerated the person with disabilities equal opportunity protection of right of full participation act 1995. But if any of the disablement enumerated in section 2N of disability act are the result of the injury sustained in a motor accident, they can be permanent disablement for the purpose of claiming compensation. The percentage of permanent disability as expressed by the doctor with reference to the whole body more often than reference to a suffered permanent disability to the extent of 45% of left lower limb. It is not same as 45% permanent disability with reference to the whole body. The extent of disability of a limb or a part of the body expressed in terms of the percentage of total functional of that limb obviously cannot assume to the extent of disability to the whole body. If there is 60% permanent disability of right hand and 80% permanent disability left leg, it does not mean that extent of permanent disability with reference to the whole body is 140%. It is different parts of the body have suffered different percentage of disability. Sum total thereof expressed in terms of the permanent disability with reference to the whole body cannot obviously exceed 100%. Where claimants suffer permanent disability as a result of injuries, assessment of compensation under the head of loss of earning would depend upon the effect of impact of such permanent disability or his earning capacity. Tribunal should not mechanically apply percentage of permanent disability as percentage of economic loss or loss of earning capacity. In most cases, percentage of economic loss, that is percentage of loss of earning capacity arising of the permanent disability, will have to different for percentage of permanent disability. Some tribunal wrongly assume that in all cases, particular extent, permanent disability would result to corresponding loss of earning capacity, and consequently, if evidence produced so 45% permanent disability, we hold there is 45% loss of future earning capacity. In most cases, equating extent of percentage of loss of earning capacity to the extent of percentage of permanent disability will result award of either too low or too high compensation. What requires to be assessed by the tribunal is to affect the permanent disability on the earning capacity of the injured after assessing the loss of earning capacity in terms of percentage of income. It has to be quantified in terms of money in arriving future loss of earning capacity, applying standard of multiplier method used to determine loss of dependency. We may, however, note that in some cases, on efficient evidence assessment, tribunal may find that percentage of loss of earning capacity as a result of permanent disability approximate same as percentage of permanent disability, in which cases, of course, tribunal will adopt the said percentage of determination of compensation. Para 12. Therefore, tribunal has to first decide whether there is any permanent disability. If to extent of such permanent disability, this means tribunal should consider and decide it reference whether disablement is permanent or temporary. If disablement is permanent, whether it's permanent total disablement or permanent partial disablement. Disablement of person is expressed with reference to any specific limb, then affect such disablement of the limb on the functioning of the entire body, that is permanent disability suffered by the person. If a tribunal concludes that there is a permanent disability, then there is no question of proceeding further, determining loss of future earning capacity. But tribunal concludes that there is permanent disability, then it will proceed to ascertain to the extent. After tribunal ascertain the actual extent of permanent disability of the claimant, based on medical evidence, it has determined whether such permanent disability has affected his affecting capacity. Now, para 15. It may be noted that when compensation is awarded by treating loss of future earning capacity as 100%, even more than 50%, the need of awarding compensation separately under the loss of amenities of
No,
or
you
loss of
were
expectation.
referring that in some judgment, it is stated that for a reference to loss of future earning capacity, Schedule 1 of the ESI Act should be looked into.
Applied. Here also.
Where?
Raskumar, I place it. Para 16 also.
Okay. Yes, please read.
Middle portion. The tribunal may also keep the view, the first schedule of the Workmen Compensation Act 1923, which gives some indication about the extent of permanent disability in different type of injuries as the case of workmen. Para 16, last portion.
It is not binding.
Not binding, but tribunal have to as a follow guidelines.
May look into.
May look into. But Lordship will find, but it was not observed. In the Motor Vehicle Act itself, it is scheduled schedule in the motor vehicle act, earlier there was a schedule. This is not a amended case. It is a case of 2015. After new amendment act, there is no schedule in the motor vehicle act. In the schedule itself, it is stated the Employees Compensation Act schedule will be followed. Injury deemed to result permanent total disablement, permanent partial disablement, or percentage of loss of earning capacity shall be as per schedule 1 of the Workmen Compensation Act. Before amendment. This is amended act. Because it is a case of 2015. Schedule. Last question, sir. Injury deemed to result permanent total disablement, injury partial disablement, percentage of loss of earning capacity shall be as per schedule 1 of the Workmen Compensation Act 1923. Disability in non-fatal injuries. That's it, got it.
Schedule 1 or
Schedule 1 of the Employees Compensation Act. That is second schedule.
no second schedule of the earlier act.
Earlier act. Amendment Act came into force 2019.
Where is the reference of Workman?
Lordship will find,
ESI Act.
Lordship will find serial number 5, disability in non-fatal accident.
Yes,
Lordship got it?
yes.
Now, B next. Injuries deemed to result permanent total disablement, permanent partial disablement, percentage of loss of earning capacity shall be as per schedule 1 of the Workmen Compensation Act 1923.
Okay. I'll give you.
And Lordship, there is judgment of this honorable court also. I'm not placing because this is not disputed fact that the schedule of the employees' compensation will be followed for assessment of loss of
No
earning capacity.
statutory provision is there. This regarding your submission that compensation against the head's loss of expectation of life and loss of and amenities ought not to have been granted.
Yes, Lordship.
This is applicable only if
When disability, loss of earning capacity at 100% or above 50%.
yes, but in the instant case, it is 50,
Considered as 80%.
even if we accept your submission. Okay, it was considered as 80%. So what is your submission? No compensation ought to have been granted.
1. Loss of amenities of life, loss of expectation of life, and 2 lakhs word for pain and suffering. Only 1.
That means instead of 6 lakhs, only 2 lakhs ought to have been granted. Okay. Yes. Anything else?
This is the sum and substance. And regarding Lordship artificial limb, with apology, I am submitting Lordship, there is no evidence from the claimant side. I can give the assessment of artificial cost of artificial limb from the statement because it is not a civil court. Tribunal have to consider the facts of each case. There is a need of artificial limb. Supreme Court has categorically stated that civil procedure code is not specifically applied. For disposal of appeal, Lordship will follow the civil procedure code order 41 for disposal of the appeal. But in this particular case, there is no evidence regarding cost of the artificial limb. Doctor was not examined. Claimant has examined himself as a evidence, as a witness. So cost of artificial limb, I can assist by Google. I can give a copy.
Okay. You provide that.
Lordship.
Yes.
What a judgment is.
Yes.
Well, regarding the ground number one, urged by my learned senior. This is the judgment I am relying on. It is 2012, 2 SCC 267. Paragraph 8 to 14.
Vera?
Paragraph 8 to 14. 267. Mohan Soni versus Ram Avatar Tomar and others. What exactly happened in that case? The appellant was a cart puller and he was dashed by another vehicle and his left leg was crushed. Applying Schedule 1 of Employees Compensation Act, 50% permanent disability was assessed and accordingly was paid. Thereafter, the matter went to Supreme Court. What the learned or Honorable Supreme Court said, may I treatment. Paragraph 8. On hearing the counsel for the parties and on going through the materials on record, we are of the view that both the tribal and the High Court were in error in pegging down and disability of the appellant to 50% with reference to Schedule 1 of the Workmen's Compensation Act 1923. In the context of loss of future earning, any physical disability resulting from an accident has to be judged with reference to the nature of work being performed by the person suffering the disability. This is what I want to emphasize, madam. This is the basic premise, and once that is grasped, it clearly follows the same injury or loss may affect two different persons in two different ways. Take the case of a marginal farmer who does his cultivation, working himself and plows his.
What you are
hands.
doing,
I'm a mason.
Mason.
And there is no cross-examination to the point that I'm not a mason. That is not being challenged to. Lordship may kindly peruse the cross of PW1.
So if your legs are amputated,
Then, my lordship may kindly see exhibit 5, the condition. Both legs are amputated below knee, my lord.
yes,
I cannot work if that is the condition of my life.
the loss is 100%.
Yes, ma'am. Therefore, I'm submitting, it should be 100%, not 80. And in this judgment, it was enhanced to 100%. Because without the two legs, he cannot work as a mason, my lord. He cannot continue his avocation. Therefore, that argument goes.
But you have not challenged the,
Even if I do not prefer an appeal, my lord, for granting just compensation, this honorable court may pass an
no,
order.
but assuming,
Yes.
if you are not at all aggrieved,
No, I may not urge, but there is a judgment of this honorable court, of the honorable Supreme Court, 2021, 16 SCC 467. This is Surekha versus Santosh,
what is the citation?
2021, 16 SCC 467. I could not get the judgment. This is Suresh versus Santosh. Where the Honorable Supreme Court said in the absence of an appeal being preferred or cross appeal being preferred by the claimants, the courts may look into for giving just compensation.
And it can increase.
Yes, it can increase, even if I don't urge by way of an appeal.
Okay.
The second point.
So in this judgment, there cannot be fixed assessment of permanent loss of future earning. Permanent loss of future earning resulting from a permanent disability. It depends upon case to case.
Yes.
Okay.
And this is exactly what the Honorable Supreme Court has laid down in that citation which I have furnished to your lordship. And regarding that 2 lakhs 3 times to 6 lakh, that is not being urged here. So the moment my learned senior urged that, I was taken aback. So that one was not in the
Ground
grounds
of
urged.
appeal, in grounds of appeal.
No, it's not there.
Ground number 3.
3, I'm not sure whether it is,
What is ground number 3?
For the award of 4 lakhs as a loss of expectation of life, amenities of life, 2 lakh pain and suffering, and cost of artificial limb, both legs of 6 lakhs without verifying the cost of artificial limb. As such, assessment of compensation considered without evidence on record, and justification is not legally sustainable and same is liable to be set aside and cost.
I couldn't follow what that's, it's a hyper technical argument because my senior is a highly experienced. So I am taken aback by this argument. I didn't go through that full bench judge. I'm sorry for that. If your lordship may kindly grant me 1 day time. So I can read that judgment and I come back. How to counter that argument.
For information, the code I'm submitting, but he is submitting that code can enhance the compensation.
No, not on that point. The second point, I also require clarification. That when the loss of future earning is assessed at 100%, 50% or above, there is no requirement of awarding compensation against the head loss of earning, loss of life amenities. That is your submission and you have cited judgment. He want to respond to that.
And for responding on a date, I could not follow this ground number 3. I'm not trying to find fault with my drafting of my senior, but I could not actually understood the real meaning that it should not be 3 times.
I should not use a specific word challenging that it is double compensation. And lordship, regarding my framed argument regarding enhancement of compensation, may I submit one thing, lordship?
No, you can do one thing because we have heard substantially. You make your submissions and the points
You can give a copy of the order.
you can give in writing.
Yes.
The gist of your argument with a copy to other side.
Yes.
If you want to respond.
Yes.
Because this needs some clarification.
Yes.
Secondly, lordship, if he has completed, lordship,
Have you completed?
Yes.
Okay, yes.
2025 5 SCC recent judgment. I can give the reference also 2025 5 SCC. Today I am not brought because this point has been settled by the Supreme Court. In case of a appeal by the claimant, as a corollary,
Appeal by claimant.
appeal by the claimant, High Court has reduced the compensation. In case of appeal by the claimant for enhancement of the award, High Court has reduced the compensation.
Okay.
Supreme Court said, this is not an appeal by the insurance company. This is an appeal by the claimant. High Court cannot reduce the compensation. As a corollary, the appeal by the insurance company, they cannot pay for enhancement also. It is already settled principle.
No, but he says that there is a judgment 2021.
That has been discussed in the subsequent judgment. Please, what he has pointed out, I will give the judgment also. If he is agree, I will give the judgment tomorrow. That-
No, you mention it in your written gist.
Lordship. Lordship.
Okay.
But consider if Workman Compensation Act has been for the workman. And here, lordship, amputation of both leg. He is, workman is workman. The Supreme Court, what has stated, this court has been held that power of Supreme Court under Article 142 cannot be exercised by a High Court in appellate. That has been decided by this honorable court. That is decided by this honorable court in.
No. This observation under para 8 of this.
2019 3 GLP for page 47.
No, that is okay. 142 power cannot be exercised by this court. That is a settled law. But what he has cited
That
is
considering the facts of the each cases, it can be loss of earning capacity can be considered a avocation. That is his submission.
yes,
Considered a avocation.
evocation. And it cannot be
Straight jacket formula.
straitjacket formula as provided in Workmen Compensation Act.
And that has been subsequent judgment, full bench judgment has settled that employees compensation act should be followed. That is, I place this as subsequent judgment where the provision of workmen's compensation should be considered.
No,
Not to follow,
the
considered,
language is, it may be looked into.
looked in.
It may be looked into, but it is not binding.
Binding, what has not been says binding, but 163A of so the schedule is specific provision that schedule.
How will you overcome this judgment? The observation made in 2012 to SCC 267, the judgment which he has relied. You respond to this
Lots.
in your written.
Lots.
You have noted the citation.
Lots. My junior has noted it down.
2012
2012 to SCC 267.
267. Para 8.
Right.
Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard
A Bhattacharya.
Mr. A. Bhattacharya. A. Bhattacharya. A. Bhattacharya, learned counsel for the respondent number,
1.
sole respondent.
No,
Respondent.
I am the claimant respondent.
Learned counsel for the respondent slash claimant.
If Lordship has noted something, then I can point out to another thing I have not pointed out. Here is a order to pay and recovery. Because we have at least defense evidence that vehicle did not have permit. So we are directed to pay and they are the recovery for the owner. Already there is an order from the cabinet, pay and recovery.
That is not under challenge.
That is not under challenge by anyone.
Okay.
So day after tomorrow, we'll give the,
When?
yes,
Day after tomorrow, Friday. Give on
Thursday,
Friday, give it on Friday.
oblige.
My lord, will it
The-
be listed or
It will be listed.
Friday I have some difficulty, my lord. I'll
Give it on Monday.
Monday.
The learned counsel for the parties are requested to give written gist of their respective arguments on the next date fixed. That is on 3rd of November 2025. List this matter as part heard on the said date. 3rd November.
Oblige.
Much obliged.
এই কিতাব মেলে কি রাখি এখন কিতাব ঘোরাই দিও you take your hold. Yes, next item.
Item 19. It will take time, little time.
It will take time.
But my lord, you can start it as much as possible, that maybe part hard. You can finish it before this hour.
We'll start on then some other day.
My lord, today, my lord, it's just a fact of the case. Within a half an hour, then on the next day, start. Because this case was initially rejected by the tribunal. And subsequently, the claimant filed the appeal. Appeal was remanded back. Then the oh, my lord, if it's something, so today I can. Fixed on the after tomorrow, man.
Yes, that prayer may be
Next, my lord.
heard, Mr. R.C. Paul.
At 2 p.m. we will-
Mr. Talukdar, you have anything to say?
I think if the matter is submit shortly, then I think it will be within the parameter of your lordship, because last case in this present case is same, almost same.
No.
No,
There is
no
a
two
minor
cases
difference.
are same.
Because this
Almost
case
same,
is.
almost, I
not
use the
almost
word
same.
almost.
But yes, as per my friend says almost same, I am just lot of difference.
My lord, the main fact is that,
We'll hear it on
Day after tomorrow.
Tuesday.
yes, it's.
Tuesday hearing day is there.
Yes.
As a part third matter.
No, I have not even heard.
Otherwise, he will start.
Therefore, I am reluctant to start.
My lord, he will start and your lordship will make it.
No, we will fix it as a fixed matter.
Thursday. Day after
As
tomorrow.
Thursday.
Yes.
Okay, heard Mr.
Two PM also.
R.C. Paul, learned counsel for the appellant, also heard Mr. I.A. Talukdar. Due to paucity of time, this matter could not be taken up for hearing today. Let this matter be listed on Thursday,
30th.
30 October as a fixed item.
Smell.
Obliged.
Much obliged.
Item 22.
Can we fix it in the next week?
Heard Mr.
Sorry.
E. Bhattacharya, learned counsel for the appellant. No one has appeared for the respondent on call. Let this matter be listed.
Tuesday next week. Can it?
No fixed date. You want a fixed date?
Yes, ma'am.
Let this matter be listed again on next week, Thursday. 6th of November.
Much obliged.